With my Lord's indulgence, my Lords, may I mention an interlocutory application which we have filed today, my Lords? This,
Interlocutory application, Mr. Chaudhary, in which
well, that matter, my Lords, writ petition civil 317 of 2024, that Rathore services.
Yes.
Now what?
But that has already been reserved for
Yes,
judgment.
yes, my Lord. Now what has happened, my Lords, is that on 7th, when your Lordship had fixed the matter, my Lords, from 4th, your Lordships had stated that insofar as the 7 tenders were concerned, my Lords, the price bids should not be open. Now, my Lords, what in regard to the other clusters which had received, I had informed your Lordships on 4th when I appeared before your Lordships physically. Your Lordships was of the view that nothing is going to happen since these were bids received on 1st. Now, my Lords, what they do, my Lords, is on 7th, when the matter is fixed for hearing before your Lordships, my Lords, they open the price bids at 10:30 a.m. in the morning. And that fact is not even brought to the notice of the court, my Lord. Something very serious, my Lord.
This is in respect of the NIT,
Yes.
In which we have this court has passed the
No,
order.
that,
Mr. Anshuman Chaudhary.
No, my lord, not those tenders.
my Lord,
My lord.
may I just say this, my Lord? The policy was under challenge, your Lordship's recalls, my Lord. In that, my Lord,
Anyway, you have filed an IA. You want that at 2 o'clock?
no, whatever it is, my Lord, it's very serious, my Lord. I wanted to bring it to your Lordship's notice, my Lord, that this is not done. They should have at least informed this court.
You are allowed. Ms. Bernali, you.
Grateful, my Lord.
All right.
My lord is
allowed. Yes.
2 o'clock, my lord. I'm sorry, my lord. Is it at 2 o'clock? So we'll have to inform the learned Solicitor General.
No. Yes. Yes, Mr. Anshuman.
I'm sorry. Is it at 2 o'clock, my lord?
No, we'll call it whenever the matter the application is placed before the court.
My lord, may I request, because the learned Solicitor General has to appear, may I request for 2 p.m. then?
All right.
If my lord is placed.
All right.
Much obliged.
Grateful.
Relating to 2016 matter.
468.
468, 420, my lord. Allegation against the petitioner that he submitted some forged.
All right, CD.
My lord, 45,000 loan
When can we have it, Mr. Das?
already repaid, my lord.
I'll give you a short date.
Friday, my lord, if possible.
No. He says it's already been paid and a matter
Paid,
of
my
2016, so have it on Friday. Which police station?
PIO, my lord, Kamrup, man.
Yeah, have it on Friday, Mr. Das. Call for CD list on Friday. 15.
Obliged, my lord.
Yes. Yes, Mr. Abdullah.
Please, your lordship. This revision is against order of appeal, my lord. Revision against appeal, my lord. Pang order is at page 31, my lord.
Yes.
Page 31, my lord.
Yes, I
Basically,
have
my
it.
lord, it's an extramarital affair between one of the persons, my lord, petitioner and a lady, my lord. Extramarital affair. Now she has claimed for DV. We have taken the plea for the London trial court also, for the appellate court also. But, my lord, our note was not favorably considered. At this stage, lordship may admit the revision, my lord. And, my lord, there is an interim order prayer. So we have preferred before your lordship revision.
Where is the order of 12/6/19?
12/6.
1 second. Yes, where is the order of
Page 18.
Page 18.
Page 18.
This is the order against which you had filed appeal.
Appeal.
You are the husband.
Actually, not husband, my lord. Actually, there was an extramarital affair. I am also a married man, and she is also a married lady. There is a
You
relation.
are not married to her.
No, my lord, I am not married. She stated I am married, but I am a married man, my lord. She is also a married lady. That plea, I have taken the appeal also. These were not considered at that stage.
Maintenance was given.
Domestic violence, my lord, it's a sort of maintenance.
Is allowed as interim monetary relief maintenance. Aggrieved party, there is no shall be pay same. 7,000 per month.
Per month.
Easy at Arson again.
Okay. I correct. I want to.
Which is the document from which you can show that you are not married to her?
My lord, because I am a married man, my lord.
Where is that finding? Is there a finding before the court below?
There is no finding from the court, but in my appeal, when it was not favorably considered, the court has stated that I have taken the plea, my lord. It is, as she is a married lady.
No, where is that? Otherwise, we are not inclined to give you any interim right now. We'll issue notice. We will consider your interim prayer after the other side appears. Unless, of course, you show me from the order itself that it is an admitted fact that you are married.
Page 25, paragraph 3, my lord. We have stated the name of our earlier husband, everything. Page 25, paragraph.
This is what? This is your application.
Application. The name of the husband was categorically stated.
There is no finding to this.
My lord, you know.
Is it?
It is difficult for us to prove. It is, the court ought to have, my lord, asked her to say that he is not her husband. Produce a divorce certificate or like that, my lord. But nothing was asked. And we have categorized in a revision petition also that she is a married lady having 2 children.
Right. Heard Mr. S.M. Abdullah, the learned counsel for the petitioner. It is a party.
A titular party, no. a formal party.
Issue notice returnable to Wix. Mr. D. Das, Learned APP, accepts notice on behalf of respondent number 1. Top extra copies within the course of the day. Steps by registered post AD in respect of respondent number 2 within a period of 2 days. Top. This is an application under section 397-401 CRPC, read with section 482 of CRPC, assailing the impugned judgment dated 27/12/2023 passed by the Learned Additional Session Judge number 2, Nagaon, Assam, in criminal appeal number 12 of 2021, whereby dismissing the appeal of the petitioner and upholding the impugned order dated 12/6/2019 passed by the Learned Judicial Magistrate First Class Koilabor, Nagaon, Assam, in DV case number 30 of 2018, whereby the Learned Magistrate directed the appellant petitioner to pay interim maintenance of rupees 7,000 per month to the respondent number 2. Top. Next para. Mr. S.M. Abdullah, Learned Counsel for the petitioner, submits that the trial court has granted 7,000 per month as interim maintenance without assigning any reason, that and that the respondent number 2 is still continuing conjugal life with her earlier husband, Pradeep Chandra. Top. Then you say, considering the submissions made and after perusal of the impugned order, comma, in the interim, it is directed that the impugned judgment and order of the Learned Additional Session Judge number 2, Nagaon, with a order dated 27/12/2023 as well as order dated 12/6/2019 passed by the Learned JMFC Koilabor, Nagaon, Assam, in DV case number 30/2018 shall remain stay.
I'm deeply obliged.
List accordingly.
Obliged.
Yes.
Wait, please, Lord, case is this, my lord. I was on bail. And in the meantime, what happened, my lord? Summons were issued on various dates. I have not received the summons. But unfortunately, my lord, warrant of arrest and PNA has been issued. A clear violation of section 73.
You have not received the summons?
Not, my lord, your lordship would be pleased to turn to page 18.
Yes.
18. I am on court bail, my lord. 8/5/18. The
Yes.
accused is on court bail. Is it? So, my lord, issue summons. Hereafter, my lord, page 19. Page 19, my lord, fresh summons again.
Yes, Mr. Das.
In itself, my lord, issue summons. Again, issue notice to bailer. Issue fresh
When
summons.
is the next date?
My lord, next date is, my lord, on April, my lord.
Where do we get that?
My lord, I'm giving you, lord. It is fixed on 5/4 like this. No. 12/4/24. Page 17, my lord.
Page?
Page 17 last. 5/2/24. 12/4/2020.
This is what? This is the order sheet.
Yes, my lord. I have typed copy, my lord. I have got this.
Right, you appear then. Till then, we
My lord.
will
One thing,
suspend the NBWA and the
my lord,
PNA that has been issued.
Only one thing.
Yes.
If your lordship directed Generally, it is directed the warrant is recalled and petitioner will appear and as per law, it will be decided. Then what happened, my lord? Court did not allow because you were absent for many days, so will put in jail. So my prayer before your lordship is this, that a clear order may go because I have not received summons. Otherwise, my lord, I may put.
Well, we will indicate that.
My lord.
Now, which is the
Indication is necessary, my lord.
impugned order?
My lord. Impugned order at page 24A, my lord.
That is 5/2/2024.
Yes, my lord. 5 to 20.
Page.
Page 24A. Last one, my lord.
This is what you have challenged.
Yes, my lord.
And five to 24.
Yes, 5 to 2024.
Can you read it? That it is not very legible.
It is, my lord, present bailor, like this. Present bailor. I have given type copy also.
Where is the
DNA
type?
and NBA is issued. Type copy at page 17. Bailor to accused person, PA, NBW is against accused, issue fresh PNA. By
So warrant of arrest was started issuing from 6th January.
Yes, my lord. It has been started from, first it was issued on
6th January.
Page 21. Yes, my lord.
So just give me the dates.
Page 21.
Summons were issued when?
Your lordship will turn to page 21.
Mr. Counsel, summon was issued when? On 8/5/18. Just give me the date.
My lord. Your lordship turn to page 21.
Yes.
6/1/2020 issue warrant of arrest and PNA against the accused. My humble submission before your lordship, for issuing PNA, there is a provision. In this way, PNA can be issued like this. There is clear provision.
Heard Mr. M.A. Sheikh, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP, state respondent. Stop. This is an application under section 401, read with section 397 of the CRPC for setting aside the order dated 5/2/2024, whereby the Chief Judicial Magistrate Kamrup within bracket M issued warrant of arrest and make it in short form, issued WA and PA against the petitioner in GR case number 1868/2018 arising out of PGR PS case number 38 of 2018. Now, the facts of the case is that the petitioner was arrested in connection with a FIR dated 13/2/2018 in Prajyotispur PS case number 38/2018 registered under section 376 IPC. Stop. The petitioner was arrested and released on bail by order dated 10/4/2018 passed by the Honorable Session Judge Kamrup M. Stop. Subsequently, charge sheet being number 24/18 dated 28/3/18 was submitted by the police under section 376 IPC and the case was registered as DR case number 1868/2018 registered under section 376 IPC. Stop. Thereafter, the petitioner was arrested in connection with the aforesaid case and by order dated 10/4/2018, the petitioner was granted bail. Then you say, though by order dated 23/19, summons was issued to the petitioner. Stop. However, he did not receive the said notice from the court of CJM. Stop. Accordingly, warrant of arrest and PA were issued against him by orders dated 6/1/2020, 21/10/21, 15/2/22, 14/6/22, 28/9/22, 1/1/23, 12/4/2023, and 21/7/2023, and 5/2/2024. Stop. Aggrieved by the aforesaid orders, the present revision petition has been filed. Stop. Next paragraph. Mr. M.A. Sheikh, Learned Counsel for the petitioner, submits that since summons was not received by the petitioner, he could not appear before the trial court, and accordingly the impugn orders of WA and PA were issued against him. Stop. Mr. D. Das, before that you said, he further submits that the petitioner is willing to appear on all dates fixed from time to time. Stop. Mr. D. Das, Learned APP Assam, submits that if the petitioner is willing to appear on all dates before the trial court fixed from time to time, he has no objections to the prayer made in the revision petition. Now, I have heard the submissions made at the bar and have perused the materials available on record. Now, it appears that since the petitioner did not receive the summons issued, the petitioner could not appear on the date fixed before the trial court. Stop. Be that as it may, this court, this court, in view of the assurances and endorsement made by Mr. M.A. Sheikh, Learned Counsel for the petitioner, to the effect that the petitioner is willing to appear before the trial court on all dates fixed from time to time, this court deems appropriate to dispose of this revision petition with a direction that the petitioner shall appear on the next date, shall appear before the court of Chief Judicial Magistrate, Kamrup Metro, on the next date, i.e. 12/4/2024, and if the petitioner appears on the said date, the WA, PA and NBWA issued against the petitioner shall be suspended. Stop. Upon appearance of the petitioner, the trial court shall consider the case on its own merit, and also keeping into consideration that the petitioner did not receive the summons for which he could not appear on the date fixed for the trial. Now, accordingly, with the aforesaid observation and directions, this criminal revision petition stands disposed of.
Your Lordship ordered that 24 I will appear. But in the meantime, it would be paid, my lord. Otherwise, I may be arrested.
All right, I will
Yes.
make that correct.
Yes.
All right.
Oblige, your lord.
Yes.
May it please your lordship. This is a criminal petition under section 482 paid with article 227 of the Constitution of India. It is this accused petitioner. He has preferred this petition against CR case that is pending against him in the learned court of Judicial Magistrate First Class, Margherita, against CR case number 22 of 2019. Now, going into the brief of the case is that he is a police person. He is currently serving as a sub-inspector in Dotasil Police Station. And while this case was being lodged, he was serving as a SI in Margherita Police Station.
NBWA was issued against you? Why?
Yes, my
you
lord.
did not appear?
My lord, the fact is that this particular this case, when it was instituted, at that time 2 other cases were also instituted against this accused petitioner by the complainant in State Human Rights Commission as well as in State Police Accountability Commission. Now, in both the cases, while he had gone for this complaint case before the trial magistrate, he had not disclosed the same before the State Police Accountability Commission. So, as such, the State Accountability Commission, in the meantime, had recorded this accused petitioner's statement. He had appeared before that, and in the meantime, this State Police Accountability Commission had disposed of the matter, stating that since it hits the double jeopardy because of the fact that already 2 complaints were there, so it was misleading on part of the complainant while not disclosing the fact while lodging it before the State Police Accountability Commission. And then when it was disposed of, it was again sent back to the trial magistrate. Now this person, now since he was serving as a SI, so in the meantime, due to his official exigencies, he had appeared through his counsel on number of occasions. And during the period of the COVID also, while this entire this judiciary was not operational due to the fact that entire state was going through that, he was not able to go. Now, when this particular NBW was issued, the first was issued on 27/2022. Then later,
where is that order?
That is in page number 25, my lord.
Yes.
That was issued against the cognizance which was taken by the Honorable Trial Court. In page number 24, that cognizance is there.
Yes.
So then it proceeded with the NBW on 27/2022. Then
So summons was issued to you on 7/11/19,
yes, my lord. It was issued to the
but you were absent on 27.
No, he had appeared before 27/2022. He had appeared. He had duly appeared in person as well as to his counsels while discharging his official.
But it is mentioned you are Digonta Kolita?
Yes, I'm Digonta.
Accused Digonta Kolita is absent. Which step?
Yes, he was always absent on these 3 occasions. Which steps? He had not missed any of
That
these.
NBWA was issued.
Yes, my lord. Now the fact is that this petitioner, now the next date is on 13/3. That is kindly carries to page number 29. That is the last order, 5/1/2024. Again, fresh NBW has been issued since he has not appeared in person on the last date. That was on,
Why are you not appearing?
my lord, because of the fact that during that period, on the last day, that was on 5/1/2024, in that period, he was busy with some of his investigation processes, my lord. So since he is a police inspector and he had performed all his duties as per the police manual. During the initial stage only when the incident took place.
Next date is 13 March.
Yes.
So you appear on 13
Yes,
March?
I am going to appear, but in the meantime, we pray that since he is in Lotus Hill Police Station, he is discharging from
You
here.
are Mr. P. Datta.
No, I am W.R. Methi, my lord.
Heard Mr. W.R. Medi, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP for state respondent. But who are these 2 private persons?
One is the son, and the other one
Informant.
the complainant and the son, the victim, against whom the complainant had.
Then we'll have to issue notice.
Yes. Notice in the meantime, notice be issued.
There are respondents.
Yes.
I think there মইত্ৰী এখন notification আছে নেকি respondent থাকিলে notice দিব লাগে এখন আছে নেকি We'll take this matter after some time. There could be a notification which says if there are private respondents without their appearance, probably disposal may not be appropriate. I'll just check for a long.
My lord,
Wait for some.
Oh, yes.
FIR Quashing.
Quashing.
Where is the FIR? It's 13.
Translated for on this. FIR is lodged by the daughter of the accused.
Page 13.
Page 13.
What is the 354 509 500?
Who is outraging?
Very vague, Mr. Das. Very vague FIR. What is... where is this news broadcast? Nothing is given.
It is given, my lord.
Where?
In the last line of the page 13, News Fast Karbi Angulam. That is the...
Aligning my image.
Well,
But
it is a satellite.
well, I noticed then. Mr. P.K. Munir, learned counsel for the petitioner. Stop. Also heard Mr. D. Das, Learned APP, Assam. Stop. This is an application under Section 482 of the CRPC 1973, read with Article 226 of the Constitution of India, seeking setting aside and quashing of the FIR registered as Bokajan Police Station case number 8 of 2024, registered under Section 354, 509, 534 of IPC. Stop. The case of the petitioner is that
What had happened?
one second. The relevant facts of the case is that one, Khushbu Hajorika, daughter of Kutumoni Hajorika, lodged an FIR before the officer in charge of Bokajan Police Station on 15/2/2024, alleging that the petitioners were involved in spreading rumor and tried to malign the image of the informant by circulating news in a channel. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. Issue notice. Returnable within 2 weeks. Stop. Mr. Das accepts notice on behalf of the state respondent. Extra copies within the course of the day. Registered AD in respect of respondent number 2 within a period of 2 days. Stop. In the meantime, further proceedings in connection with the FIR registered as Bokajan Police Station case number 08 of 2024, registered under section 354, 509, 534 of IPC, dated 15/2/2024, shall remain stayed. Stop. List according.
My lord, for Quashing the complaint.
Where is the complaint?
Complaint is, my lord, 13. Petitioner, my lord, were the bearer of Student Union of Harvard College, and they raised, my lord, on behalf of the Student Union and on behalf of whole. And this FIR, my lord, lost by respondent number 2, alleging, my lord, whole allegation, my lord, page 16. There are 5. Complaint registered under section 500 and 506. Now regarding defamation, whether defamation is affected, and matter is, my lord, purely a concealment of the fact. There are 5, my lord. May I read you?
Yes, yes.
That the complainant begged to state that he was shocked to see that on 22/10/2022, the above named accused person, along with some other person, hold a press meet the college campus, and in that
But
press
there are allegations of defamation. Why should we scuttle this criminal proceeding at this stage?
worship actual fact is, my lord, page,
At best, you will get a notice from this court,
page
nothing
23,
else.
my lord.
Yes,
This,
OP,
this
right.
is the factual fact.
You are Mr. K. Bhuya? Heard Mr. K. Bhuya, stop. Also heard Mr. D. Das, Learned APP for the state respondent. Stop. This is an application under section 482 of the RPC, seeking quashing and setting aside of the impugned complaint in CR case number 80 of 2023. Stop. Issue notice, returnable 2 weeks. Mr. D. Das accepts notice on behalf of the state respondent, extra copies within the course of the day, registered post AD in respect of respondent number 2 within 2 days. Stop. List after 2 weeks on a date to be fixed by the registrar.
Worship,
Interim to be considered the next.
worship matter is subject before this one.
No, no.
Because the
We shall not scuttle the complaint case. Yes, next. Yes, Mr. Bhuya?
Yes. My
FIR?
I'll know, my lord, whole criminal proceeding, my lord,
Yes.
and I'll try to satisfy this honorable court. I'll take indulgence of few minutes, my lord. Fact is this. 2020, my elder brother, whose name is Raj Shekhawat, got engaged with a girl. Ring ceremony was done. 2022 April, he came to know with regard to antecedents of this particular girl. So marriage was cancelled. Now she calls for a press conference wherein she makes a complaint to all Assam Us Rajbangshi Student Union. That I have an act. Now, thereafter, on 7/7, my lord, ancestral home is there, my lord, wherein 3 stories building, 1 story building, puja was organized on 7/7/2021. That is 3 months after the marriage has been broken. She all of a sudden enters my house. I am a married person, my lord. I work for UNESCO, my lord. And I was there, my wife was there, my brother-in-law, my sister-in-law, my sister, and the Purohit is also there. Now she comes in and she doesn't want to leave. Being a law-abiding person, my lord, I went to the police at 9:15 around. And thereafter I went there, then OC was not there, then another police officer, I called from this. Everything is on record. Then at 10:15, GD entry has been made. And thereafter police came in, took her out from my house, taken to police
It
station.
was on your...
Yes.
Instance.
Oh, yes. And thereafter, my lord, at 8 p.m. on the next day, she comes in, laws and affair with regard to rape allegation against the brother, elder brother, my lord, which is not before the court. So far, my allegation is concerned, I have molested her. Now, if your lordships, I will take your lordships to each and every document.
You
FIR,
filed
my
for
lord.
quashing the FIR.
My lord, I have coming to all of
Whole
the
proceeding.
quashing, my lord, with regard to this. Because quashing of the FIR is very limited when
But it
I
is
have
the
limited scope.
basis is the FIR.
Yes. So, my lord, in the FIR it's been alleged, her 161 statement I have annexed.
What does she say in her 160?
161 altogether different version, 164 altogether different version, and when she was taken to medical, my lord, date of occurrence is also different. Happens to be different. And my lord will kindly see, I have annexed the cases wherein, my lord, my elder brother is at Guwahati, my lord, wherein she files an FIR that I tried to snatch away her belongings and everything. Case were registered. Then I made myself available, my lord. The CCTV camera
Are
shows.
you on bail?
Well, I am on bail. I am on bail. I am.
Where is the FIR?
Yes. May I take your lordship to serially, my lord?
Yes.
Yes.
FIR first?
No. Before that, my lord, may I take your lordship to page 24, my lord? With regard to Manish Shekhawat.
Your GD entry.
You know, my lord, that is the certificate wherein, my lord, with regard to this, my lord, Manish Shekhawat.
That's all right.
Yes. Then, my lord.
Mr. Bhuya, you have come under 482.
Yes.
So let us see what the FIR is.
I'll come. Before that, my lord, will kindly see page 25, my lord. This is an application 25. This is an application made by her before Akrasu. That's what I mentioned about. When she doesn't say rape and anything, well, with regard to.
This is where? This was made before?
Before, my lord, Akrasu, AKARSU, Student Union.
Achha.
This been a document, my lord. And my lord will kindly come to page 27.
Raj
Khetawat. He's not before the court, my lord.
is the brother
Brother,
of the
elder
petitioner.
brother.
Elder brother.
Yes.
All right.
27, my lord, will kindly see the phone records, my lord. At page 27, I have typed it 772156. I called up the OC and the
Very
IO.
well, Mr. Bhuya, please come to the FIR.
Yes. My lord, FIR, before the FIR, may I take your lordship to the GD entry, my lord?
GD entry, I've understood. You have intimated when she had come to your house,
Yeah,
correct?
that is very important. At page 30, my lord, will kindly see.
Page?
30, my lord. Time is there, my lord, at 7/7/2021, 10:15. I am reading it, my lord. Manish Shekhawat, is it so-and-so, 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 so-and-so? Basically has informed the police that a girl, namely so-and-so, forcefully entered into house and her house is at so-and-so. For the reason she entered his house, he cannot say, and he came to know from the girl that the said girl and his brother, Raj Shekhawat, so-and-so, love relationship, but he proved to his brother is presently not there and he is in Guwahati and asked her to come later, but the girl refused to go back to her home, so-and-so, so-and-so, escorted. This is the GD entry, my lord.
All right.
Now, my lord, the GD entry copy is page 31. I have translated copy, I have read it. Now, my lord, page 32. 32, my lord, is the format, wherein she comes in after around 24 hours. Information received, 8/7 on 8:10 p.m. Page 32, this is the format.
Yes.
And my lord will kindly come to the FIR at page 34, my lord. I'm not reading the first portion.
Occurrence is on 7, huh?
My lord, this is on 8.
So the occurrence is 7/7.
7, wherein I made the GD entry on the basis of which police came
Very
and
well.
took her out.
Very well.
34, my lord, will kindly see.
Yes.
11 line for the last, my lord. So far, incident of 7/7/2021. In the right side, my lord, kindly get in the event 7/7/2000, on 7/7/2021. There was a puja in the house of the accused number situated at Golokganj, and the accused number 2 invited the informant, attended to puja. Accordingly, at 2 p.m., the informant went to the house of accused number. I have annexed my call record. I have not called her. After completion of the puja at about 10:30, and after leaving all the people, the accused number 2 forcefully touched her, so-and-so, and other body by hand. When the informant resisted, he gagged her mouth by clothes and tried to establish so-and-so, so-and-so, tried to kill her. This would amount to, my lord, 354. Now, my lord, during investigation, my lord will kindly see all 161 statement I have annexed. Page 39, my lord.
Accused number 1 is?
Elder brother.
And you are
younger brother, my
younger
lord, who is married, my lord. Page 39, my lord.
Accused number 2 is the young.
Yes.
Page
39, 161 statement.
Towards the end, she says, and the accused number 2 called the police.
Yes.
Right.
She's admitting that. On 7/7, I called the police. She was thrown out.
So, in this FIR, there is no allegation against you as such.
7/7 is with regard to Manish Shekhawat.
7?
7, my lord. In the FIR, my lord, 7/7, the second portion, my lord.
No, there was a puja in the house of.
Yes.
And the
On
accused
7/7,
number
there was a
2,
puja in the house.
In accused number 2.
Of the accused number 1. Situated at Golokganj. Accused number invited me for the puja.
Oh, okay.
So I have annexed my call details, no calls.
Forcibly touch her.
Yes.
That part is.
Yes. Now, my lord, will kindly come to 161 statement. Page 39, I have bolded, my lord.
1?
At page 39.
39.
That is the informant's, my lord, 161.
Yes. On 7.
Whole person, my lord.
Yes, yes.
This is it. Another room, indecent intent, touch my so-and-so at different body, so-and-so, which I tried to restrain. When I was being gagged, then Gamusha, so-and-so, so. Then, my lord, will kindly say 164 now. At page 62. I take your lordship to your mother and her own sister's statement also.
Yeah, there are allegations.
I'll come to that, my lord. Let me satisfy, my lord, the parameters on which I am arguing this matter, my lord.
Of course, you may have a case.
Yes,
at the
my
time
lord,
of hearing, that is a different thing.
my lord, I'll try to
Page?
satisfy
Page?
62.
62.
Her 164 statement. Last line, my lord, this is with regard to this.
The bolded portion.
Yes. Their family members regarding the subject decided to sit on 6/7/21. They invited us to their puja. Now, my lord, again the bold portion. After puja, I discussed with the brother Ras so-and-so with Manish and his brother-in-law regarding marriage. His brother-in-law told that you both talk, I am here, by saying that his brother-in-law went out towards the road. There was an argument between me and the brother of Raj so-and-so regarding marriage. At the time of argument, suddenly he grabbed my shoulder. Thereafter, he grabbed me tightly and he used force against me. There was a guard in the road. That's 164. Now, may I take your lordship to her own mother's statement, my lord? That is page 40, 161.
Page?
40, my lord. Her name is Purnima Roy, my lord. Nothing with regard to molestation.
Purnima Roy is the
mother of the informant. Nothing.
Was she around?
She was not around. She went back to her house. And she narrated with regard to these incidents. But she never narrated with regard to molestation part. No whisper, my lord, will kindly see. And she is the truth.
All right, then.
My lord, next witness is sister of the informant, my lord. Kindly see. I am reading it, my lord. My name is so-and-so, so-and-so, so-so. I know the incident that my sister Itiro and Ras Sekawal were in love. According on 31/7/2020, ring ceremony was held between both of them along with presence of family members invited. And we also have the photograph of the said ring ceremony. People from our village also came. After the ceremony was over, the family member Raz used to visit our place and Iti also used to visit their place. Now we do not know what happened. The family members Raz Sekawat wanted to marry Iti in the month of April, but the mother could not manage the money for the wedding ceremony. And as such, we had to postpone the wedding. Raz stays in Guwahati because of his work purpose. Sometimes he visits his house. He used to meet my sister as well. On 7/7, my lord, will kindly see. On 7/7, a ritual puja started for their new house. I have heard that Raj did not come to the said puja, but my sister Iti went to the said rituals, and I came to know that Raj's mother invited her over phone. I also heard that after the ritual puja got over at 8 p.m., Raj's brother, namely Manish Shekhawat, asked Iti to go to her house. And he also said that how will Iti go to her house this late?
It looks
which
like
I
he
came to know from
refused to marry her.
elder brother and
No, younger, yes.
Yes.
Raj.
So, my
Raj
lord,
refused to marry.
She called out. My lord will kindly read these lines in between this. And he also know that to go to Iti's house, which this late, which I came to know from Iti. And I also came to know that that time Manish Shekhawat was with his wife, brother-in-law named so-and-so. I have heard from Iti mouth that Raj's brother-in-law Ashim Adhikari along with Manish Shekhawat are going to drop
Alright,
Iti to
Mr.
their
Bhuya.
class. Iti told me she has refused to go to her house.
Number 12. Heard Mr. A.K. Bhuya, learned counsel for the petitioner, stop. Also heard Mr. D. Das, learned APP, state respondent, stop. This is an application under section 482 of CRPC 1973 for quashing of a criminal proceeding arising out of an FIR in connection with Golagganj PS case number 724/2021 registered under sections 417, 493, 354B, 384, 376, of IPC. Stop. The case of the prosecutrix is that on 7/7/2021, while there was a puja in the house of the brother of the petitioner at Golagganj, he had visited and after the completion of the puja at about 10:30 p.m. and after all the people left, the petitioner forcefully touched her chest and other parts, and when the informant resisted, he gauged her mouth by cloth and tried to establish sexual intercourse and tried to kill her. Stop. Mr. A.K. Bhuya, learned counsel for the petitioner, submits that the informant and his elder brother were in a relationship, and on 7/7/2021, when his brother was not in the house while a puja was going on, the informant had come, and later she had refused to and after the completion of the puja, he had refused to leave the house, and for which the petitioner had informed the jurisdictional police station, and accordingly a GD entry was made. Which is at which page? GD entry?
Page,
yes,
my lord,
I got it.
30.
GDE number 178 dated 7/7/2021.
At 10:15.
At 10:15 p.m. He further submits that since his brother had refused to marry the informant, he had manifestly with Malafide filed an FIR on the next date, I
8/7/21, page 32.
8/7/2021 at about 8:10 p.m. Stop. He further submits that the victims, that the informant's mother and sister has stated in their 161 statement recorded by the investigating officer to the effect that Purnima Rai and Ruptara Rai, right?
Yes.
To the effect that the brother of the petitioner has later on disagreed to marry their daughter, and also that Mr. D. Das, you have nothing much to say. I don't think so. You want to say anything? What flimsy grounds? Here, on the face of it, it looks this has been malafide, manifestly attended for malafide, because it appears she had that boy has refused, and it appears when she had gone, the entire family was there of the petitioner. Her own family is also supporting them as of now. Anyway, this matter will ultimately have to be put on hearing. But till then, we can always protect.
Mr.
Didas has opposes the prayer stop. Issue rule returnable with 2 weeks. Mr. Das appears accepts notice on behalf of the state respondent. Extra copies over the course of the day. Registered E in respect of respondent number 2 with NIP. It appears from the materials available on record that the petitioner on 7/7/2021 at 10:15 p.m. while the informant had come to their house to meet his brother, who was with whom he is alleged to have a love relationship, and refused to leave their house, had informed the Golagganj PS, and accordingly a GD entry number 178 and stop. Further, it appears from the statement of Ruptara Rai, who is the sister of the informant, that the informant and the brother of the petitioner were in a relationship, and ring ceremony was held between them on 31/7/2021. Ring ceremony on 31/7/2020, sorry.
No,
31/7/2020. He further stated that on 7/7/2021, a puja was going on in the house of the petitioner where her sister had gone. And after the puja got over at around 8 p.m., the petitioner asked the informant to go to her house. And at that time, the wife and brother-in-law of the petitioner were also present in the house. And she further came to know from the informant that though the petitioner and the brother-in-law wanted to drop her in their car, he refused to go to her house. Stop. It appears from the aforesaid material that the petitioner has laid out a prima facie case that the FIR has been lodged by the informant manifestly actuated with malafide and stop. Keeping that in mind, court in the interim directs that further proceedings in connection with FIR dated 8/7/2021, registered as Golagganj PS case number 724/2021 under section 417, 493, 354, 384, 376, 511 of IPC, and charge sheet being Golagganj PS case number 691/2021 dated 31/10/2021 shall remain stayed till the next date.
Next.
Stop.
Deeply obliged.
List after clear date after 2 weeks. List on 27.
Sessions case number 167.
One second. List on 27/3/2024. Stop. जो टू भी लिखिला Golagganj PS case number. What was the last charge sheet की लिखिला?
Charge sheet number is there. And the
691,
session
2021
edition session judge Dubri.
I have it. 1 second.
Yes.
There you write arising out of Golagganj PS case number 724 of 2021.
Yes.
Impugned charge order dated 9/1/2024 passed by the additional session judge Dubri in sessions case number 167/2023.
Deeply obliged.
Yes.
Please, Your Lordship. My Lord, this section 482 filed before Your Lordship, keeping a minimum, saying for a direction that in the event of when to the magistrate on 19/3.
Which is the order you have challenged?
My Lord, we have received someone. In this case, why we have filed this petition? Because this charge sheet has been submitted, showing me absconded, without visiting my residence, without any investigation, without being noticed to us by the police station. That is why I am not aware about this case, my Lord. However, I am ready to appear on 19/3/2004 before the SDGM.
Where is the order?
Order, my Lord. At page 26, my Lord. 27, my Lord. 24/8. Accused Rukumar Das is absent with steps. Right petition number so and so. Hard the prayer is allowed. Next, my Lord. Last page, my Lord.
Yes, which is the order you are aggrieved with?
Yes.
Mr. Das, which is the order?
Order, my Lord, order has not been challenged. My lord, what happened in this case, my lord? Without searching me,
You are absent with steps, and 19.3 is been fixed for appearance. So you appear. What is
Yes.
the problem?
I will appear
Then-
because I am apprehending. Because
What apprehension do you have?
apprehension, my
You
lord.
appear on
My lord.
19.3.2024.
Yes, absolutely correct, my lord. My lord, what happened in
Mr.
this
Das?
case?
Correct, I've seen that.
Yes.
So what is the apprehension?
Yes.
I have not understood.
Apprehension, my lord.
Do not make a 482 an abuse of the court process. For
My lord.
everything, you don't need to come under 482.
Lord.
There is no impugn order
Lord,
against you.
Your Lordship,
Where is the order? What are you apprehending?
we did not challenge the order, my lord.
You are not appearing. You are
lord.
taking steps. On 24/8 also, you are absent with steps. 21/11 absent with steps.
Yes,
2012 absent
yes,
with steps.
yes.
Now what do you want
My
from
lord,
this court?
I am apprehending.
Sorry.
That the investigating.
There is no merit
my
in this
lord.
case.
As the investigating agency played in the search sheet,
This
issue
is item number
non-bailable
13.
warrant and declare absconder. That is why, in the event of my appearance, I may be remanded to the jail hazard.
No, you appear there. If something happens, then you
Sir,
come.
let-
It's premature.
A direction may kindly be given to
No, no.
consider the prayer, my
All right, we have heard you. Heard Mr. N. Ahmed,
Yes.
learned counsel for the petitioner. Stop. Also heard Mr. D. Das, learned APP state respondent. Stop. This is an application under section 482 of the Code of Criminal Procedure 1973, seeking for a direction to the learned subdivisional judicial magistrate Hojai Shankardev Nagar to release the accused petitioner on bail in the event of his appearance before the said court on 19/3/2024. Stop. Mr. N. Ahmed, counsel for the petitioner, submits that the petitioner apprehends that upon his appearance on 19/3/2024, he may be arrested and accordingly seeks a direction for bail by filing a petition under section 482 of the CRPC. Stop. Mr. D. Das submits that there is no merit in this petition and it is an absolute abuse of the court process. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears from the order sheet annexed that it appears from the order sheet of the subdivisional judicial magistrate Hojai Shankardev Nagar that the petitioner who was charge-sheeted for trial for offence under section 120B 376 511 506 IPC cognizance was taken by order dated 17/10/2022 and summons were issued. Stop. Thereafter, it appears that on subsequent dates, I 18/1/2023, 12/6/2023, 24/8/2023, 21/11/2023, and 20/12/2023, the petitioner was absent with steps showing cause, which was allowed. Stop. 18/1 to Nalaga. That may be first time. It may not have been. Yes. 18/1/22. Further, it appears that the case is now fixed on 19/3/2024 for appearance. Stop. In such circumstance, it appears that there is no merit in this petition seeking relief under section 482 CRPC. Stop. It appears that the present petition is an abuse of the court process and accordingly is dismissed. Stop.
one observation by kindly be.
Next.
May I please, Your Lordship? 482 application for quashing of criminal case number 57, 2023, pending before the Court of Civil Judge Junior Division number 2, come Judicial Magistrate.
Where is the order?
Uh,
Complaint case. You want the
Complaint
quashing of complaint case.
Yes,
Where is
sir.
the complaint?
Annexure A, page 14.
Yes.
Yes, Lordship, the respondent here filed a case against me along with 5 others, stating that we, under section 120B, 420, 424, 465, 468, 471 of IPC, stating that while the petitioner hearing preferred a Miss J, that is annexure B, I forged the power of attorney.
You forged the power of attorney.
attorney, which was annexed. And along with it is also mentioned that the other respondents, along with the petition, accused, along with the present petitioner, are creating chaos in the T state.
We will issue notice at this stage.
Yes, sir.
You are Mr.
M.R. Sodial.
Heard Mr. M.R. Sodial, learned counsel for the petitioner, stop. This is an application under section 482 of CRPC for setting aside and quashing of complaint case number 57/2023 pending before the learned court of Lucillo B. Datta, Civil Judge Junior pending before the learned court of Civil Judge Junior Division number 2, come Judicial Magistrate First Class, Walpara. Stop. Issue notice returnable with 2 weeks, registered post AD in respect of respondent number 1 and within the period of 2 days from today. List after 2 weeks of data that list on 28/3/2024.
Deeply obliged.
May I please, the Lordship, for the
Yes.
application, Lordship, for passing of a complaint under 138 NI.
Talukdar, quashing of?
NI, 138 NI.
Yes.
The Lordship will kindly find in page 17, allegation.
Yes.
According to the complaint response number 2, I took a loan of rupees 10,83,000. And thereafter, we entered into an agreement on 2140. That when returned the amount as 15,29,160.
Yes.
Thereafter, what happened? On 25/11/21, according to him, I issued a check of 71 lakhs.
And I. Yes.
So now the present case is of 71 lakhs, 6,320.
Yes.
So my submission is the legally enforceable debt of 71 lakhs is not there. Because initially, according to the complaint, in page para 2, your page
10 lakh, 10 lakh 83.
Thereafter, we entered into an agreement that I will return 15 lakhs and all. So day after that also lapsed. Now in the year 21, according to the complaint, I issued a check of 71 lakhs 6,000. So where is the legally enforceable debt of 71 lakhs? Whereas the actual amount was 10 lakhs 83,000.
Yes.
On that ground alone, Lordship, the complaint petition is liable to be put. And another ground is there because there is barred by limitation. And Supreme Court decision I am passing it to your Lordship, where it has been stated that section.
This is under what section?
138 of the Negotiable Instrument Act.
The check bounce.
Check bounce. But then there should be a legally enforceable debt because there is no legally enforceable.
Where do I get that? In the
because
section?
admittedly the amount was taken by me was 10 lakhs.
From the section,
Oh,
please show me.
138 of the married.
Yes, yes.
Where any check drawn by a person on an account maintained by him with a banker for payment of any amount of money to another person from out of that account or for the discharge in whole or in part of any debt or other liabilities returned by the bank unpaid either because the amount of money standing to the credit of the account is insufficient. So that is the part.
Yes. Where is it mentioned legally?
That's not legally enforceable, Lordship.
Is it, Mr. Baudavan?
There is a formal party. A clear case of Lordship abuse.
No, notice will be issued, but Mr. Talukdar is not only on notice.
I am praying for stay because Lordship will kindly see the Supreme Court decision, Lordship, I have sent.
No, but Mr. Talukdar, from it appears that a check of 70
1 lakh.
odd was issued, right?
Right.
Which ultimately
But
was
there is no legally
dishonest.
enforceable debt.
Where do you show that from?
From the complaint itself.
No, from 138 doesn't talk about that. It says where any
it has
check
to be.
drawn.
It has to be legally enforceable.
Where do you say that from?
Debt or other liability. Explanation also.
What is the decision that you have given?
Decision is regarding limitation. Because the agreement took place in the year 2014. So for 3 years it was there. Thereafter again there was lapse of 3 years. So thereafter that limitation goes. The paragraph 15 you also will kindly see. Of the Supreme Court judgment.
I have a little reservation about this first part of your argument about the.
That is to be.
Is there any authority on that point? Are you
Legally
hearing
enforceable, it has
anything?
to be. Without legal enforceable debt, one cannot issue a check.
That
Because
we
that-
don't know. There will be a presumption
No,
right
admittedly,
now.
Lawsuit kindly see.
There will be a presumption right now. This is.
Lawsuit kindly see. in
Correct, I
para-
have seen.
para
Paragraph
two, he has-
2, paragraph
he has
2, it
admitted-
is 10 lakh 83.
that
correct?
is the only.
Yes.
That is my liability towards the payment. So thereafter they entered into an agreement that at the rate of 2% I will pay. That was 15 lakhs 29 1. Now how come this 71 lakhs? That is not a legal part of the agreement also. That too in the year 21.
Maybe this is with interest. We don't know.
No, interest was, if you calculate with interest, so then also it did not come to 71 lakhs. Because the amount was 10 lakhs. And again, that's why I'm saying.
Because 139 is there. It
Presumption-
shall be presumed unless the country is proved that
Country
the
is
holder of a check received the check of the nature referred to in
that is
section
presumption. That is
138
during trial.
of the discharge. Exactly. So
Lawsuit.
now at
Now your lawsuit
before
can
even
see-
issue at the
Supreme Court
notice
decision
stage,
of- Supreme Court
how will
decision-
this court?
Apparently, because it's apparent.
The
It's not
presumption
le-
is there
is
under
no legally
139.
enforceable
If
debt of
they,
71.
after they appear and then something happens, that is a
Daniel
different
also will
thing.
kindly see the decision I have given. Para 15. Because here.
Para?
Para 15 of the 1.5. Because the limitation also goes out here. Because agreement was made in the year 2014 for a period of 3 years. Thereafter another 3 years lapsed. So the bill of actions has to be. Para 15 laws. A perusal of the above extracted emphasized portion would indicate that the promise is to repay the principal amount with the interest accrued within December 16. Hence, when the respondent agreed to repay the amount within December 16, the cause of action to initiate proceeding to recover the said amount if not paid within December 16.
Here, there was a promise that it would be repaid with interest within December 2016.
No,
So
here,
if,
here
in this case of the Supreme Court, correct?
cause of action
And
to-
if the repayment is not done within 2016, then the limitation
that limitation of 3 years
3
will
years
come.
from December 2016 because
Will
from yes. Now in,
Now
this,
let us
in
come
your
to our
case,
case. In
what
our
is
case,
the promise?
Lordship will kindly see the agreement is page 30.
Page
30.
agreement is there.
It's there.
Yes.
That they have themselves annexed. Promissory note. That was done on 21 2014.
21, 14.
14.
And by when
For a
the
period of 3
repayment?
years. For a period of 3 years, that will be
Where do I get it?
from in the page 30.
3
Promissory
years
note.
is mentioned.
Page
No,
30.
no. This is a promissory note.
Promissory note. That is executed between the complainant and me. That 20 January 2014. That you also will find. 20th of January 2014 for a period of 3 years. So that will be 15, 16, 17.
The repayment is given in paragraph 3.
3. That is within
Moreover-
a period of 3 years. That will be 17. So 14, 15, 16, 17.
In equal 36 monthly installments.
Yes, that is 36
which
will be 3
starts
years.
from 15 February 2014.
Gotcha.
So that expires when?
That is that expires on 2017.
2017.
2017.
From there, if
Then
you
there
take
is a waiting period of 3 years for
3
filing
years.
case.
Correct.
Then that will be
That
18,
will be
19, 20.
20.
18, 19, 20.
And this
this was filed in year 22.
This 3 years expires in
Expires
2020, right?
2020. Right.
And the complaint is filed when?
In the year 2022.
2020. All right. Okay. In item 15. heard Mr. D. Talukdar, learned counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, learned APP. You are a party or not?
A formal
party is there
Formal party.
for state respondent. This is an application under section 482 of CRPC 1973 for quashing of the complaint case being CR case number 1113 of 2022, which is now pending before the Court of Learned Judicial Magistrate First Class Kamrup within bracket M at Guwahati. Also, I need to mention the order dated.
I have challenged the order also.
And
2/4/2022.
and quashing of the order dated 2/4/2022, whereby the Learned Judicial Magistrate First Class Kamrup M at Guwahati was pleased to take cognizance of the offence against the accused petitioner under section 138 of NI Act 1981 in CR case number 1113 of 2022. So, the facts of the case is that the respondent number 1 filed a complaint petition before the Learned Chief Judicial Magistrate Kamrup Metro at Guwahati on when is the complaint dated? On date not there. Just leave it blank on so and so date. Under section 138 of the NI Act, stating inter alia therein that the accused petitioner was in dire need of money and the respondent number 1 complainant, being in friendly relation with him, gave a sum of rupees 10,83,300 as loan. Stop. It is further stated in the complaint that the accused petitioner and the respondent number 1 complainant has entered into an agreement promissory note on 21/20/14, where the accused has admitted that he borrowed a sum of rupees 10,83,000 as a loan and also promised to pay an interest at the rate of 2% per month to the complainant on the balance amount outstanding at the end of every month. Stop. It was also agreed between the parties that the accused shall repay the principal amount as well as rupees 15,29,160 in 36 installments, which was scheduled to start from 15 February 2014. And thus the accused was supposed to pay rupees 42,489 per month to the complainant. Stop. Further, it is stated that in spite of repeated demands for payment of the loan amount, he has not paid the amount and therefore issued one check with a check number 480708 dated 25/11/2021 for an amount of 71,606,320 drawn at State Bank of India, and on presentation of the aforesaid check, the same got dishonored due to funds insufficient with the check return memo dated 26/11/2021, and accordingly present complaint petition has been filed against the petitioner.
It was filed on 8/2/22.
8/2/22.
2022.
2022. Next. Mr. D. Talukdar, the counsel for the petitioner, submits that the aforesaid complaint petition is barred by limitation, and in support of the aforesaid submission, he relies upon the decision of the Supreme Court in the case of K. Himavati versus the state of Andhra Pradesh and others. Stop. paragraph 15 and 16 of the said paragraphs is quoted hereunder for ready reference. I have heard the submissions made at the bar and have perused the materials available on record. Issue notice returnable with 2 weeks. Returnable 4 weeks. 4 weeks. If the P. Borthakur, learned APP, accepts notice on behalf of respondent number 2, extra copies within the course of the day. Stop. Notice by registered post AD in respect of respondent number 1 within a period of 2 days. Stop. It appears that in the present case, in terms of the promissory note dated 21/2014, the petitioner had agreed to repay the loan amount with interest in equal 36 monthly installment, which was scheduled to start from 15th of February 2014. Stop. In terms of the aforesaid agreement, the petitioner had promised to repay the entire loan with interest by 2017. Stop. However, he has failed to. However, it appears that the aforesaid loan has not been paid within the stipulated time period. Stop. Be that as it may, the informant has not taken any steps in law within the period of 3 years from the date on which the petitioner had promised to liquidate the aforesaid loan amount. Stop. It appears that the present complaint has been filed on 8/2/2022. Stop. By applying the principle laid down in the case of E. Himavati versus the state of Andhra Pradesh within bracket Supra, it appears the aforesaid complaint petition is barred with limitation. Prima facie barred with limit. As such, in the interim, further proceedings of the complaint case being CR case number 1113 of 2022, which is now pending before the Court of Learned Judicial Magistrate First Class Kamrup M, shall remain state till returnable date until further order.
March.
Yes.
This is an application for quashing by complaint petition under section 130 of Negotiable Instrument Act against. Complaint petition is page 25.
Page
25. Annexure B.
Page 25, yes.
Annexure B.
Annexure
B.
Yes.
Here, the accused number 1 and 2 is the company. Accused number 3 is the signatory and chairman of the company. For myself.
Yes.
And 5 is the employee, and 6 is the accountant of the company.
Yes.
Here, my contention is that I'm one of the directors.
Allegations are clearly there. You have issued the checks.
No, I have not issued them.
Then?
Here, the allegation is in para 2 of the complaint petition, which is at page 27.
Yes. You are accused number?
I'm accused number 4.
Yes.
The
director.
The accused number 1 and 2 is the public limited company. The accused number 3 is the chairman, who is the signatory. Accused number 4 is the director. I am.
In NI Act, I think vicarious liability is there, isn't it?
Vicarious liability is as per section 141 of the Negotiable.
Yes, offences by companies.
Yes, offences by company.
Yes.
Section 141 of the company.
Yes.
Act.
Read.
If the person committing an offence under section 138 is a company, every person who at the time of offence was committed was in charge of and was responsible to the company for the conduct of the business of the company, as well as the company, shall be deemed to be guilty of the offence and shall be liable to be proceeded against and
So
punished.
here they have already, in the paragraph 2 itself, they have averred that all the accused persons are related to the day-to-day business, correct? And 4 and 5 is responsible person for the day-to-day business. So that allegation is there on the face of it.
Here, allegation against me is that I am the director of the company. Only that much. Allegation against 5 is that he is responsible person for the day-to-day business, and the accused number 6 is that he is the chartered accountant of the company.
Yes, and as such, all the accused persons.
They presume.
That's right, but you see, that allegation is there. Whether it is correct or not correct, that is different.
Section 141 is very clear. It's a mandatory provision, and both the conditions must be fulfilled. Here
anyway, at this stage, we will issue notice. Whether it is correct, not correct, this is for not this court to go into at this moment.
That's because they have
used the word. We'll give you a short date.
My lord.
You are Mr.
A. Cabra.
A. Cabra. Heard Mr. A. Cabra.
I want to submit one citation. I want to submit one citation.
No,
because they have used it as such. And the Honorable Apex Court has said that as such is a presumption of the complaint.
Mr. Cabra, we shall consider that on the next date while we consider your interim prayer. Not today.
Can you take...
Sorry. This is an application under section 482 of CRPC 1973 for quashing of the impugned criminal complaint proceeding bearing CR case number 2104/2016 pending in the court of Judicial Magistrate First Class Kamrup Metro Guwahati against the petitioner. Stop. Issue notice returnable with 2 weeks by registered post steps by registered post AD with a period of 1 day, 2 days. Stop. Date at adjournment. List again on 27/3/2024. Stop. Interim prayer shall be considered on next.
Till that.
Yes.
Please, Your Lordship, my lord.
Yes.
This is an application under section 38, my lord, 438, my lord. May I take a lordship to the FIR?
This is
FIR,
438.
On 10, my lord. Page 10, my lord. Here, my lord, the FIR was lodged against the petitioner brother, my lord, who is a Prabir Vishwas, my lord.
Yes.
Where it alleged by the informant that is 5 gram of gold for making 2 ring and 3 gram of gold to make one with pokhara stone to repair the chain, my lord. This is the alleged allegation against my brother, my lord. So though I am apprehension, the police is now and then coming to my resident, my lord. Here, my lord, I have also annexed all the documents, my lord, where we do not stay together, my lord. He stays separately, I stay separately, my lord.
All right.
And my lord, I am an old person.
Yes,
my
all
lord.
right. Yes. It's all right. Let him appear.
My lord, one thing, my lord, he's a cancer
I am
patient.
giving you interim. Do you want something else?
Nothing, my lord.
But please take your seat. You are Mr. K.D. Chetri?
My lord.
Heard Mr. K.D. Chetri, learned counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, learned APP for state respondents. Stop. This is an application under section 438 of CRPC 1973 for granting of pre-arrest bail to the accused petitioner, i.e. Sri Ratan Kumar Biswas, who is apprehending arrest in connection with Jalukbari PS case number 68 of 2024, registered under section 420, 413, 411, 406 of IP. Stop. Call for the case diary fixing on 9/4/2024. Stop. Considering the facts and circumstances of the case, it is provided that in the event of arrest, the petitioner named above shall be released on interim pre-arrest bail in connection with the above noted case on furnishing bail bond of rupees 15,000 with one surety of like amount to the satisfaction of the arresting authority, subject of course to the following conditions. Number one, appear before investigating officer 7 days, and inducement and similar offence. Next.
Much obliged, deeply obliged.
366. Minor. Call for case diary. List on 27/3/2024. Next. 307.
Yes, Your Lordship. Your Lordship, apparently Your Lordship, CD has to be called for, Your Lordship.
Call for CD. List on 28/3/2024.
Lordship, but Your Lordship, there are also cross affairs. Your Lordship. Petition number 2 is is a woman, Your Lordship.
402499.
My lord. That's it, yes. Trial has been going on, my lord. For pandemic, my lord, he was appeared. The petitioner was appeared. But after pandemic COVID-19, my lord, they are not appeared. That is why warrant. So they may be considered appear, and on appearance they may be allowed to go on.
Huh? Where is that? This is a...
Next date is fixed on 4/5/2000.
Where do I get it?
That session code.
Where from your... which annexure you get the next date?
My page 19 to 20.
Page?
19 to 20.
19?
19 to 20. What are it?
NBWA issued and the next date is 19/6/23.
No,
then
next date is fixed on 4/5/2020.
4/5.
4th May
20?
24.
24.
Due to COVID.
COVID has gone so many times, you have defaulted by now. This is an application under section 438 of the Code of Criminal Procedure 1973, praying for granting of anticipatory bail to the petitioners, i.e. 1, 2, 3, 4, 5, and 6, who are apprehending arrest in connection with session case number 51 of 2016, which is pending before the Session Judge Kamrup M at Guwahati, arising out of Jalukbari PS case number 971/2013 and registered under section 399402 IP. Stop. It appears from the materials available on record that the petitioners have not appeared before the trial court for which NBWA were issued against them. Stop. Your name?
Islam.
MDB Islam? Mr. MDB Islam, learned counsel for the petitioner, submits that the petitioners are willing to appear on the next date. Stop. considering the aforesaid submission, this anticipatory bail application is disposed of with the direction to the petitioners to appear before the trial court on the next date fixed. And till then they'll be protected. Until then, they shall not be arrested. It is made clear that upon appearance, trial court shall be at liberty to consider the bail application at its merit. Disposed of. I shall come back in 5 minutes. Yes.
My lord, FIR is page 10, my lord, 430 application, my lord. Allegation of 306, my lord. My lord, from the perusal of the FIR, it appears that there is no ingredient against the petitioner, my lord. Rather, petitioner has taken the victim to the hospital, my lord.
AB?
AB, my lord.
Borthakur?
Praying for some protection, my lord.
There was love relation, it says. Okay, short date. Call for CD list on 23/2024. Obliging. Six. Do you have instructions?
No, my lord. 1 year.
Take your instructions then. According to them, charge sheet has been filed. So if so, then you make necessary changes. Right? It is submitted. Mr. P. Borthakur, learned APP for state respondent, submits that in the meantime charge sheet has been filed. So, Mr. Your name? M.J. Borwa.
M.J. Borwa.
Mr. M.J. Borwa, learned counsel for the petitioner, seeks some time for obtaining instructions. Stop. List this matter after 2 weeks on a date to be fixed by the registry. Mrs. M. Chatterjee. M. Chatterjee, learned counsel for respondent number 2, is present. All right, where you say he submitted a charge sheet. By charge sheet number 263/2023. 260 of 23. Dated 31/7/23. None appears for the petitioner when the matter is called. List after 4 weeks on a date to be fixed by the registrar. Inter admission as a supplementary. You will borrow. One is the baki kita mat. Carry lock. Anyone in item 60?
May I please? Interim order at page 10.
What are you challenging here?
Maintenance order, that is, my lord, 4,000 for the petitioner and 1,000 for the child, my lord.
Page?
Page 14, my lord. Relevant.
Will admit and fix this for hearing? This is an application under section 397/401, read with section 482 of CRPC, assailing the impugned order dated 14/10/2022, passed by the Judicial Magistrate First Class Sunitpur in MR case number 18/2019, registered under section 125 CRPC, whereby the learned trial court was pleased to grant a maintenance allowance to the respondent number 2, despite of having no ground for granting the same. Stop. Admit. You said heard the petitioner. Stop. There appears to be an arguable case. Stop. Admit. List after 2 weeks. What a date did you? List on 28/3/2024 for hearing. Mr. Chaudhary, that matter.
Item 27, my lord.
You already passed the order. You are not there.
I just missed it, my lord. I am sorry, my lord.
In item 27, you say that non-appearance. Say heard Mr. B.M. Chaudhary. Give his name and what did he say after? It is fixed after 4 weeks. We'll make it 2 weeks or 4 weeks.
My lord, this matter is fixed in the
We've
lower
already, it's gone. So you want it after 2 weeks?
My lord.
2 weeks. Next. Right. Next. Yes.
Petitioner is paying for Jima of his card.
Some report was called. Has the report come? Who's appearing, Mr. Das? RC.
Also annexed.
So it is registered in the name of the what vehicle? What vehicle? Which is the order that you are challenging?
Yes, 38.
Page
38.
Yes.
Edit.
Yes.
Today is fixed for passing necessary order. Peruse the case record feels that this order to a petition filed by petitioner who has claimed ownership and sought for.
So at that time the IO could not ascertain the owner. Now the IO has asserted. So has the IO filed any report? So stating he is the owner. So that's what I'm saying. After 23, 10, 12, 21, there has been some verification of that vehicle. So should we send it back to the court and let the IO submit a report? We'll do that. Because by order dated 2310, which is on 12, which is under challenge, at that time it says the IO could not assert it. But now since they have submitted the copy of the RC, so let this please, it will not be possible here, isn't it? Okay. Your name?
Yes, sir.
Heard Mr. S. Alam. Stop. Also heard Mr. K. Das, learned APP for state respondent, and Mr. P. Bora for respondent number 2, insurance. Oh, you are the top. This is an application under section 482 of CRPC challenging the impugned order dated 23/12/2021 passed by the learned additional chief judicial magistrate Nagaon in petition number 2532 of 2021 filed by the petitioner rejecting the prayer of the petitioner for giving interim custody of the vehicle of the petitioner bearing registration number AS02W4851, which was seized by the police in connection with Juria PS case number 196/2020. Stop. It appears from the next para. It appears from the impugned order dated 23/12/2021 that since the IO by filing a report has stated that it is difficult to ascertain the owner of the vehicle, the prayer for custody, interim custody of the vehicle was rejected. Stop. During pendency of the aforesaid case, a report was called from the concerned IO as regards the status of the vehicle. Today, it is submitted by Mr. Devdas, learned APP Assam, that the petitioner has submitted the copy of the registration certificate which indicates that the petitioner is the registered owner of the subject seized vehicle. In view of the aforesaid, this court is of the considered view that this criminal revision petition, criminal petition can be disposed of with the direction to the petitioner to submit the aforesaid registration certificate before the court of Additional Chief Judicial Magistrate Nagaon, and thereafter the Court of Additional Chief Judicial Magistrate Nagaon, after calling for a report from the concerned IO, dispose of the said application. Decide fresh the application of the petitioner. It is needless to clarify the said exercise shall be carried out within a period of 1 month from today. Petition stands disposed of.
I beg your pardon. Item number 57. I wasn't.
Just one second. Hold up, did you? Yes.
Even item number 57, I was.
Huh?
Item number 57, Lordship, I could not appear. I was in.
We've already passed. If you want your name to be recorded, please tell my court
Lordship,
master.
the statutory period will be over within 2 days, Lordship.
You should have been there. Then at a short date.
Lordship, the bail petition will be.
All right, we'll give you a short date.
Lordship, bail petition will become infructuous, Lordship.
Why were you not there when the matter is called? Wait for some time.
Lordship, Lordship.
At 2. We'll call you a matter at 2.
Lordship, 57.
That's what he did. OP cancel the order. Yes, Mr. Das.
This is a matter, my lord, where the appellant petitioner was convicted under 138, my lord. Convicted for 6 months, but the appeal, it was made 3 months, and to pay compensation of rupees on 2,03,000. And the petitioner has paid that amount, my lord. And the other side is also executed, and my lord, notary money affidavit that they have received, my lord.
Where is that affidavit?
Yes, page 67 of the appeal, my lord.
67?
Yes.
But other side is not, notice is not.
Yes, my name, last time they appeared. Just
Otherwise, respondent notice has already been completed, correct?
Yes. And in IA, Lordship, kindly see, in paragraph, third paragraph, they admitted about this.
Page IA, there is an IA?
IA, my lord, there is a connected IA.
The IAS. Is the IA disposed of, Mr. Nath? What was the IA for?
IA was for continuation of delay, my lord. And Lordship is
paragraph?
IA number 224.
Yes. Paragraph?
205, my lord. 205. Small order, my lord.
IA 205?
205. Continuation petition.
I read IA 205. Huh?
Yes.
Yes. Paragraph?
Third paragraph.
Yes.
My lord, paragraph, third paragraph.
Yes.
In your counsel, appearing with the evidence submits that matter in the meantime has already been settled outside the court. Mr. K.D. Chetri, loudly counsel the PD, respondent number 1 also confirms the same, my lord. The lordship can peruse in page number, my lord, 67 of the petition, my lord. Page 67
of the petition?
Yep, yes, my lord.
Page?
Paragraph, page 67. Last paragraph. Paragraph 4. Page 60.
This is that affidavit?
Yes, my lord. Anita Chakraborty, respondent number 1. In the last paragraph.
Yes.
Bottom, my lord.
Paragraph 4?
Yes. As per the amicable settlement outside the court with Sarmishta, the petitioner, on 12 to 24, I received the entire amount of compensation of rupees 2,03,000.
Okay, you had otherwise sought quashing of the proceedings?
My lord. Now, my lord, under 146, my lord, this is a compoundable offence once the money is paid, my lord. That lordship is aware, my lord. There are 2 judgments also by the appeals court.
Yes.
So, virtually, should the lordship in that view of the matter, my lord, the judgment of the apex court, lordship can include this, my lord, saying that matter has been settled out of the money, my lord.
What is this criminal appeal?
Appeal, my lord. In my lord, initially, the trial court convicted her for 6 months, my lord.
So here you are seeking quashing of setting aside of this order?
Yes, my lord.
Of the appellate court?
Yes, my lord. Of the appellate.
Item numbers. Third, Mr. M. Nath, Learned Senior Counsel, assisted by Mr. A. Chaudhary. A. Roy, Learned Counsel for the petitioner. Stop. Also heard. Is private respondent there? No.
Private respondent is there.
No, government?
Government is there. Respondent number 2.
Also heard Mr. D. Das, Learned APP for the state respondent. Stop. None appears for respondent number 1 when the matter is called. Stop. This is an application under section 401 read with section 397 and 482 of CRPC 1973, assailing judgment and order dated 6/6/2023 passed by the Learned Additional Session Judge number 1 Kamrup M. Guwahati in criminal appeal number 49 of 2020, whereby whereby the judgment and order dated 29/2/2020 passed by the learned judicial magistrate first class Kamrup M. Guwahati, PR case number 3619 of 2017 was upheld. Stop.
Page 58, operative point.
Page
58, operative point.
Mr. Learned Counsel for the petitioner submits that in the meantime, the matter has been settled out of court, and in support of the aforesaid submission, he draws the attention of the court to the affidavit sworn in by the respondent number 1 before the notary public Kamrup M, which is annexed at page 67 of the petition. Stop. A perusal of the aforesaid affidavit indicates that the complainant stroke respondent number 1 have deposed on oath that the parties have amicably settled the matter outside the court, and in terms of the amicable settlement, she has received entire amount of compensation of rupees 2,03,370 from the petitioner. Stop. Mr. K.D. Chetri, Learned Counsel for the respondent number 1, confirms the same. Stop. Copy on top. Mr. K.D. Chetri can stand Stop. In view of the aforesaid endorsement made by the Learned Counsels for both sides, this court is of the considered view that in view of the amicable settlement arrived between the parties, nothing survives in the present criminal petition, and the impugned judgment and order dated 6/6/2023 passed by the Learned Judicial Session Judge number 1 Kamrup M in the criminal appeal number 49/2020 arising out of judgment and order dated 29/2020 passed by the Learned Judicial Magistrate First Class in CR case number 3619 of 2017 is hereby set aside, is hereby suspended. With the aforesaid observation, this petition stands disposed. All right.
There's no point. Yes, my lord.
Sorry?
He's asking what happened. I said, there's no point. You received the money. There's no point of keeping it alive, my lord. Now, it will be released on, my lord, on production of anything, my lord.
I've already set aside.
Set aside. Set aside. My lord. My lord.
Nothing remains, isn't it?
My lord. Not suspend. Lordship is suspended.
The order is suspended. That means nothing. It's the same thing. Set aside only.
My lord. Pablo is mine.
Lordship, regarding that notification, there, Lordship, referring
Item 9.
Item 9, regarding that
Yes,
recalling of the NBW.
Sir, you are ready to appear.
Yes, I am ready to appear. Only thing is that in the meantime,
You shall not be arrested.
yes, you are.
That is your prayer. Yes. This is an application under section 482 of Code of Criminal Procedure 1973, read with Article 227 of the Constitution of India, for quashing of the complaint case number 22/2000. You are also seeking quashing of the
Yes,
complaint
yes,
case?
yes. Recalling of the NBW as well.
That we are not granting.
My lord, then NBW, recalling of NBW, I will go and appeal.
So with that we will dispose it off.
Yes.
Quashing of complaint case number 22 of 2019 pending against the accused petitioner before the Court of Learned Judicial Magistrate First Class Margaritia under section 2945325342352 IPC and order dated 7/11/2019 passed by the Learned Court of Judicial Magistrate First Class Margaritia taking cognizance of offences under section 294325342 of IPC against the present accused petitioner after 227 of the Constitution of India for setting aside inter alia, and then you delete all that complaint case. Yes, and you please say inter alia, order dated 5/1/2024 passed by the Learned Court of Judicial Magistrate First Class Margaritia, wherein fresh non-bailable warrant of arrest was issued against the petitioner in connection with CR case number 22 of 2019. Stop. Mr. W.R. Medhi, yes, Learned Counsel for the petitioner submits that the petitioner is willing to appear before the which court?
Court of Judicial Magistrate.
Before the Court of Judicial Magistrate First Class Margaritia on the next date. On the next date?
Correct, 13.
On the next date, I-13/3/2024. Stop. Mr. D. Das, Learned APP for the state respondent, does not submits that the petition can be disposed of with the direction for the petitioner to appear before the court below on the next date and next date. Subject. Stop. Then you say, in view of the aforesaid endorsement made by the counsel for the petitioner, this court is of the considered view that this criminal petition can be disposed of with the direction that the petitioner shall appear before the Court of First Class Judicial Magistrate First Class Margaritia on 13/3/2024. Until then, he shall not be arrested. Stop. Upon his appearance, the court of so-and-so shall consider the prayer for, shall consider the matter on its own merits. Stop. Accordingly, this petition stands disposed of.
Obliged.
Rashid submitted.
कोई प्रश्न
Very well, but against this accused, charge sheet has been submitted. Heard MS T. Rajkal, Learned Counsel for the petitioner, also heard Ms. B. Das, Learned APP, State Respondent. Stop. This is an application under Section 439 of CRPC 1973 for granting regular bail to the petitioner who was arrested on 9/1/2024 in connection with Jingya PS case number 01/2024 under sections 363, 370, 3708, 371, 372, 373, 374, 34 of IPC. Stop. So, since charge sheet has been submitted, we will grant. What is the to produce her before the court? Mr. Das, he can be produced before the court, and the court can consider. We can dispose of it that direction, right? On the next paragraph. Mr. Das, Mr. D. Das, learned APP submits that charge sheet. The meantime has been submitted in the case. Right? PS number 05/2024 dated 27/2/2024 in connection with Jingya PS case number 011 of 2024. The WT message dated 28/2/2024 is kept on record. In view of the above, so I will do that then, Mr. Das. Let the petitioner be produced before the court. This bail application stands closed with a direction to produce the petitioner before the which court? Before district and session judge Vishwanath Chariali within 1 day. Within 1 day from today, and upon production, the said court shall consider the prayer for regular bail on its own merit. Disposes of the bail petition.
Arrested on 10/2, my lord. Today is 30 days in custody, my lord. FIR is page number 8.
Is diary, Mr. Das? Not received? Received. How many days?
30 days, my lord.
30 days. Where is the FIR?
Yes, page number 8 is the translated copy, my lord. And 11 is the vernacular. Petitioner is not a named accused. Page number 8 is the translated copy. 436 allegation, my lord. One Jafar Iqbal and one Munna Lashkar are the FIR named accused person, my lord. Married, my lord.
1 second. Yes, anything, Mr. Das? Is there any injury report? The shop was burnt. So it was a planned act.
My lord, that was mentioned.
Do you need them for investigation? This is bail. 30 days they were in custody. Do you further need them? What about their antecedents? Are they habitually doing anything? Any report on that? Nothing. Do you need them further? Because material is there, all right, but that alone cannot be a factor, right? If
my lord, one of the co-accused, my lord, who stated the name, my lord, the main accused not.
heard Mr. K. Mira.
MJ, my lord.
Huh?
MJ Kadi.
Your name is not there?
Yes, his name may be recorded, my lord. He's there.
Huh?
Mira's name is.
Your K. Mira.
Yes.
Heard Mr. K. Mira, learned counsel for the petitioner. Stop. Also heard Mr. K. Das, learned APP for the state respondent. K. Das. Earlier also summarized it. This is an application under section 439 of the Criminal Procedure Code 1973 to release the petitioner I. Najmul Hussain Laukar on bail, who was arrested on 10/2/2024 in connection with PS case Chakli Chera PS case number 183 of 2023, registered under section 29450643634 IPC, corresponding GR case number 1174 of 2023. The case of the prosecution is that on 13/10/2023, the FIR named accused person had threatened. Najmal is also one of the accused, no?
Not Malad, not Malad.
Najmal is not. Had threatened the informant while he was coming to his shop, and when the informant protested, they threatened to kill him. And there stop. It is further alleged that thereafter, on 15/10/2023, at about 1:30 a.m., the informant was informed by local people that his shop was set on fire. Stop. Accordingly, FIR was registered. Stop. Mr. Meera, Senate Counsel for the petitioner, submits that the petitioner is not a named accused in the FIR, and the petitioner was not present on the day of the incident. Stop. Next para. Mr. K.K. Das, learned APP, on the other hand, strongly opposes the prayer for bail. Stop. So his presence has been confirmed by. No, that is not there.
Not.
About him, he was there in the meeting. He further submits on the basis of the materials available in the case diary that there are materials to show that prior to the incident there was a meeting in which the petitioner was present, wherein they had hired another person to execute to burn the shop of the informant. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. Considering the totality of the circumstances, and that considering the entire facts and circumstances of the case, it is provided that the accused petitioner named above shall be released on bail in connection with the above noted case with a bail bond of rupees 30,000 with one surety of like amount to the satisfaction of the learned
PJM
Aila Gandhi, subject to the following conditions. Number 1, shall cooperate with the investigation officer. Number 2, inducement. Number 3, refrain activity. Return the up-to-date case diary. This bail application stands disposed of.
Item number 30 and my lord.
PD, Mr. Das? Yes.
Item number 30 and 48, my lord, from the same CD, my lord.
30 and
48, my lord.
48. All right. 48 to do. Yes.
Here, my lord, FIR, your lordship will find at page 10, my lord.
FIR is at page?
Page 10, my lord. Here, my lord, 4 petitioners there, my lord. Petition number 1, 2 and 3 is, my lord, behind the bar from my lord, last 49 days, my lord.
1,
2 and 3, my lord.
1 is Ansarul.
Ansarul, my lord.
Anjuma.
Anjuma and Fuljar, my lord.
Huh?
And my lord, Fuljar. There, my lord, behind the bar.
So where are the names given, Mr. Counsel?
Page number 2, my lord. 2 and 3, my lord.
Yes. 1 is.
Ansarul, my lord.
Since when 1?
1, 2 and 3, my lord, since 23/01/2024.
How many days?
49 days.
Yes. And?
Petitioner number 4, my lord, 46 days.
40, yes. Come to the FIR.
FIR is at page 10, my lord.
How many persons are involved?
Here, my lord, in the FIR, my lord, 3 names are there, my lord.
And subsequently?
Well, my lord, 4 persons were arrested, my
lord. So, say 4 are here and the other 4 are in the next case?
In my lord, next case, my lord, 1.
1 is there. All right. Yes.
In the FIR, lordship, page 10, my lord. May I read, my lord?
Yes, please.
Today on
Take gold.
Lordship,
yes.
Today on 21/1/2024 at about 8:30 p.m. received one information from a reliable source and as per source input, one boy and a lady were carrying some suspected material suspected to be fake gold. with them for the purpose of sitting a person in Nagaon, contacting in a phone number such and such, traveling in a night super bearing reception number such and such, yellow color Shelvandi bus. Accordingly, a police party was detailed by OPS headed by me, and at about 8:45 p.m. stopped the above mentioned vehicle at Vipuria bus stand. The suspected boy and lady with a style as done by the source.
Yes, Mr. Das, you need them for further retention? 46, 49 days. Who is the boy? Because this small pieces of suspected to be gold was recovered from the boy. Has it been confirmed whether this is gold or not gold? But not come. FSL is not there. Similar offense.
Only because of this, my lord, I was arrested, my lord. Otherwise, my lord, in the present affair, my lord, there is no, my lord, allegation against my
Anything
lord.
against these petitioners otherwise? What implicating materials are there? Boat has been recovered from where? From petition number 3. From petition number 3. So then 3 we will not give right now.
Even then, my lord, period of detention, my lord.
3 similar offences your antecedent is also not supporting you.
Only because of that, my lord, I was arrested in this case, my lord. Otherwise,
1, 2 and 4. But 1, 2 also are regularly involved.
Update, my lord, 49 days, my lord, and my lord, so far, my lord, carrying of my lord.
Moinul is Rosidul. Who is Moinul? Moinul is in the other one. For him, there is nothing.
For my lord, section. No sitting has taken place, my lord, till yet.
The council, we've heard you. If you keep repeating your submissions, you will not get bail. We are considering your case. We are looking into the case diary. If we can give you bail, we will surely give you. But if there is something, then we will not be exercising our discretion in your favor. Item number 34. Heard Mr. K. Borwa. Mr. K. Borwa, DORU. Learned counsel for the petitioner. Stop. Also heard Mr. K. Das, learned APP or state respondent. Stop. This is an application under section 439 of CRPC 1973 for granting regular bail to the petitioners, i.e., you will find their names 1, 2, 3 and 4. 4 names are there at page 2. Okay. Who were arrested in connection with the Puria PS case number 11 of 2024, registered under section 120B 406 489D 489 of IP 1860. Next para. The case of the prosecution is that on 22/1/2024, an FIR was lodged before the jurisdictional police station stating inter alia that upon receipt of information from a reliable source to the effect that one boy and a lady were carrying some suspected materials suspected to be fake gold, comma, a police party went and apprehended them who were travelling in a night super, and upon search some small pieces of suspected to be gold were recovered from the petitioner number 1, which was carried inside his shoe, and on search the petitioner number 2, a gold color boat shaped metal piece suspected to be fake gold was recovered. Stop. Accordingly, FIR was registered. Stop. Mr. Bora, learned counsel for the petitioner, submits that the petitioners number 1, 2 and 3 were arrested on 23/1/2024 and petitioner number 4 was arrested on 26/1/2024 and accordingly they have been languishing in jail since last 49 and 46 days respectively. Now, he further submits that considering the length of detention, the prayer for bail should be granted. Now, Mr. K.K. Das, learned APP, on the other hand, strongly opposes the prayer for bail. Now, he submits on the basis of the materials available in the case diary that there are implicating materials available, that there are implicating materials collected by the investigating officer during investigation against the petitioners. Now, he further submits that there are materials indicating that the petitioner number 1 and 2 are regularly involved. Petitioner number 1, 2 and 3 are regularly involved in similar offences. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Now, it appears from the materials placed before this court that the accused person has confessed their involvement in the crime before the police. Stop. It further appears that the investigation reveals that there are involvement of more co-accused in the case, and along with their other accomplices, they run a well-organized nexus of fake gold smuggling and fake currency note smuggling in different parts of Lakhimpur district in different districts of Assam. Stop. It further appears that fake gold has also been recovered from the house of petitioner number 3. Stop. The allegation are grave and the investigation is at a very crucial stage. Stop. This court accordingly is of the considered view that it would be in the interest of the investigation that the other accomplices are also apprehended, and the same is not possible unless further interrogation is done of the petitioners. Stop. As such, the prayer for bail at this stage, regular bail at this stage, is rejected. This disposes of the bail application. This is in item 30. And in 48 also you write similar. Okay? Same thing, but here only difference will be there is not this person is named in the FIR. No, He's named in the FIR. Anything recovered from his possession? So I will edit this order and it. Otherwise the same order.
Your Lordship, granted, my lord, my lord, AB, my lord. Nothing has been recovered, my lord.
This is an AB.
40, my lord. 48, my lord.
48. All right, rejected. Sorry, you because serious objections are there. Return case diary.
Yes, right.
Item
Right.
48. It is Anticipatory B.
It was.
Mr. Chaudhary, just 1 second, please.
439, my lord. Arrested on 10/2.
Item number 31.
31, my lord.
Yes.
Allegation, my lord, that they got an information that when abortion was going to take place.
Abortion.
Abortion was going to take place. When they have gone there, they did not find anyone, except they found some material articles in the house of the present petitioner is a nurse. He is a nurse, my lord, after 37 years of service, my lord. 52 years, having one kidney is no longer there, my lord.
One?
One kidney she has donated to her son, my lord. She is now in custody, my lord.
The allegation
my
is
lord,
that she was aborting a minor child.
no, they got information that one minor abortion is going to take place on a minor girl. They have gone there,
But they could not find.
They did not find anyone.
But they did find some
Materials, some
instruments.
articles in the house of the
Instruments.
This is the everything all seized also, man.
So,
All
case
seized,
of
ma'am.
suspicion.
Yes.
On the basis of the
Exactly.
whatever has been seized.
30 days today, my lord.
But the girl is not.
No.
Oh. FIR is at page 18.
Man. Page 18. Second line, my lord. On 9, a second information received from reliable source that Rashida is.
How many days?
30 days.
Mr. Das? Heard Mr. H.R.A. Chaudhary, Learned Senior Counsel, assisted by Mr. I.U. Chaudhary, Learned Counsel for Petitioner. Stop. Also heard Mr. D. Das, Learned APP, State Respondent. Stop. This is an application under Section 439 of CRPC 1973 for granting regular bail to the petitioner, i.e. Rashida Khatun, for who is in custody since 10/2/2024 in connection with South Salmara PS case number 30/2024 registered under Section 312/315 IP. So, the case of the prosecution is that on 9/2/2024 an FIR was lodged inter alia alleging that an information was received from a reliable source that the petitioner, who is a nurse in District Civil Hospital, Hatsingya Mari, Assam, is going to conduct an illegal abortion of a minor girl in the early hours of morning. Now, it is further alleged that accordingly a team led by the informant and other officials rushed to the place as per the information, and upon reaching
Second paragraph, last two lines. Second paragraph, last two lines. When raided,
the minor on whom the abortion was to be conducted was not found. Stop. It is further alleged that the team recovered unauthorized possession of tablets, hand gloves, surgical gloves, bandages, injections, calcium and vitamin D3 tablets, etc. from a room which was set up as a clinic in her residence. So, accordingly, a case was registered. So, Mr. H.R.A. Chaudhary, Learned Senior Counsel, submits that the petitioner is innocent and who is innocent and is working as a nurse, no?
Yes.
And who was working as
For last
A&M. What
37
is
years.
A&M?
A&M.
What does A&M mean?
A&M manad auxiliary nurse. Auxiliary? Huh?
Who was working as a nurse.
Nurse.
Nurse in GK PHTL block under South Salmara, Mankachar district.
Right.
For last
37
for
years.
last 37 years. Stop.
No complaint at any point of
And that there was never any complaint against her of similar nature or otherwise prior to the said incident. Stop.
Auxiliary nurse.
auxiliary nurse and midwife. A&M.
Auxiliary nurse and midwife. Okay? Of nurse. Mr. D. Das, learned APP, on the other hand, submits that except these tablets and all are used for abortion.
But not ascertained by the department also. It's short.
That apart from the informant and his team, after on reaching the place of incident, did not find any minor girl, as was reported to have been admitted therein for an illegal abortion. So, he further submits that only few surgical items, including he further submits that only the seizure list indicates recovery of medicines and hand gloves, bandages, and injections, and some, what is DNC? And few instruments, medical instruments. Stop.
Which was seized.
I have considered the submissions made at the bar and have perused the materials available on record. Stop. Considering the aforesaid, considering the entire aspect of the matter and the length of detention, court is of the considered view that further detention of the petitioner is not justified. So, accordingly, it is provided that the accused petitioners named above shall be released on bail in connection with the above noted case with a bail bond of rupees 30,000. 30,000 with one surety of like amount to the satisfaction of the learned
Chief Judicial Magistrate.
Chief Judicial Magistrate
South Salmara,
subject to the Mankachar, subject to the following condition: 1, corporate investigating officer; number 2, inducement; number 3, similar activity. Return the case diary. This disposes of the bail application.
Your Lordship, I am an unusual player. Item 40, CD is not here.
Item
44.
44.
Huh? Oh, yes, that's obliged.
One is there. What does she say? She has not? She's not married to him. So there are no incriminating materials as in item number 32. You are UK Burman?
Yes.
Heard Mr. UK Burman, learned counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, learned AP State respondent. Stop. Corporacom. This is an application filed under Section 439 of Code of Criminal Procedure 1973 for grant of bail to the petitioner, i.e. Rakesh Malakar, who has been arrested on 21/2/2024 in connection with Dispur PS case number 136/2024 registered under Section 420, 376, 385, 294, 323, 506, 34 of IP. The case of the prosecution is that the informant, by filing an FIR, alleged inter alia that she was introduced to the accused through Facebook, and the accused, with the promise to marry her, continued entering into sexual relationship. Stop. Mr. U.K. Burman, learned counsel for the petitioner, submits that the accused person is totally innocent and has not committed any such offence as alleged. Mr. P. Borthakur, learned APP, Assam, submits that there are no incriminating materials collected against the petitioner during investigation by the investigating officer. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears from the statement of the the informant recorded under Section 164 CRPC that the informant and the petitioner were in a relationship, and the petitioner had refused to marry her. Stop. It further appears that the informant has stated in her 164 statement that there was consensual sexual relation between the informant and the victim. Stop. Between the informant and the accused petitioner. Stop. Next paragraph. Considering the entire aspect of the matter, comma, this court is of the considered view that prima facie there are no materials of 376 available on record against the petitioner. Stop. Accordingly, it is provided that the accused petitioner named above shall be released on bail in connection with the above aforestated case with a bail bond of rupees 10,000. 10,000 only with one surety of like amount to the satisfaction of the learned TJF Kamrup M. Guwahati, subject to the following condition. Number 1, cooperate with investigating officer. Number 2, inducement. Number 3, 1 and 2, return the case diary. This disposes of the bail application. Submits on the basis of the funds.
His name is only Rakesh Malak.
Huh?
Name.
His name is
Rakesh Malak.
Rakesh Malakar. Rakesh Malakar is to file by. Yes, dispose of. Mr. Parashar is appearing. Case diary? Yes.
Lordship, before asserting to the FIR, if your Lordship permit me, I would like to take your Lordships to page number 10, my Lord.
Yes.
Who am I, basically, to introduce myself? At page number 10,
All right, FIR now.
at page 15, my lord.
Yes.
I read.
Yes, yes.
This is to inform you that on 27/2/2024 at about 10 p.m., information was received that an institution, namely Saraigat Cooperative Society, situated at Chijubari, Hatigao, opposite city laws, having its members, namely Zakir Hussain and others, used to extort money from the innocent people under Hatigao PS jurisdiction and running illegally money lending business without any proper registration. Accordingly, above reference GD was made by OC Hatigao PS and entrusted me to cause an inquiry in that regard. During my inquiry from the reliable source, it has come to light that the following persons, namely Zakir Hussain, had been running illegally money lending business without proper registration under the disguise of running a cooperative society. The accused persons lure innocent needy people to take loan from them and by fraud and inducement of rendering financial assistance obtain valuable securities such as checks, deed of agreement, of blank stamp papers, etc. Soon after the victims deliver their signatures, accused persons start extorting huge amount of money from the innocent people against their borrowed money. The accused persons demand a
Yes, Mr. Parashar. It appears that this probably a loan must have been taken enough.
Yes.
And when could not repay it, they should have been registered under the money lending?
No, my lord. It's a society's registration.
Collected money?
Yes.
Okay, okay. Okay. How many days? Petitioner is who?
Petitioner is the secretary, my lord.
Secretary of the society.
Of the society, my lord.
Well, it's a registered society.
Yes, my lord. It's a registered society.
Very well. Further detention, you have already, statements have been recorded, right? You are BM Deka?
Yes, my lord.
Heard Mr. BM Deka, learned counsel for the petitioner. Stop. Also heard Mr. KK Parashar, learned EPP state respondent. We are considering the bail. Yes. This is an application under section 439 of the Code of Criminal Procedure 1973, praying for granting bail to the accused person, namely Zakir Hussain, who was arrested on 28/2/2024 in connection with Hatigao Police Station case number 38 of 2024, registered under section 120B, 420, 421, 422, 423, 386, 387, 34 of IPC. Stop. The facts of the petition, the facts of the prosecution is that on 28/2/2024, an FIR was lodged inter alia stating that as per information, an institution, namely Saraigat Trading and Cooperative Society Limited, where an illegal office for lending money to different people of the locality as well as others by at high rate of interest taking mortgage of valuable property was going on. Stop. After the information, the OC jurisdictional police station had directed the complainant to proceed to the above mentioned place, and Upon reaching there, a search was conducted at the office of the Cooperative Society, and the petitioner, who is the secretary, was arrested. No. Mr. P.M. Deka, Learned Counsel for the petitioner, submits that the petitioner is no way involved in the alleged allegation and he is no way connected with the allegation made in the FIR, and that the entire allegations brought against him in the FIR is totally false. Stop. He further submits that the accused person, that the petitioner holds the post of secretary in the Soraighat Trading Cooperative Society Limited, which is registered under the Assam Cooperative Societies Act 2007, wherein the adopted bylaws permits lending of money to its members for its economic welfare. Stop. Next para. Mr. P.K. Parashar, learned additional PP, opposes, on the other hand, opposes the prayer for bail. Stop. He submits that the investigating officer has collected passbook of the society, blank stamp papers, agreement between members, agreement between the petitioner and the members of the association, Stop. Of the society, sorry. Stop. Next para. I have heard the submissions made at the bar and have perused the materials available on record. Stop. Next para. It appears from the materials available in the CD that the Cooperative Society lends money to its members, and the same is permissible under the bylaws adopted. Stop. It further appears that the said cooperative society is registered under the Assam Cooperative Societies Act 2007. Stop. It further appears that the statement of the petitioners have been recorded under section 161 CRP. As such, this court is of the considered view that further detention of the petitioner is not justified. Considering the entire aspect of the matter, it is accordingly provided that in the event, it is accordingly provided that the accused petitioner named above shall be released on bail in connection with the above noted case with bail bond of rupees 30,000 with one surety of like amount to the satisfaction of TJM Kamrup M. TJM Kamrup F, subject to the following condition. 1, 2 conditions. Return CD, bail petition disposed. Yes. Yes, Mr. Ahmed? His diary? Yes.
Petitioners' lordship are in custody since last 7 days.
67?
They were arrested on 01,000.
It had come the other day, I believe, when it was 60 days. Day 67?
67.
Yes. Where is the FIR?
FIR lordship is at page number 20.
Yes.
May I read it?
Yes, yes.
I have the honor to report that today on 3/1/20 at Swans, acting on a tip-off, the secret reliable information received by above reference that some persons are about to deal and deliver fake gold and fake currency by keeping their position at 8 Mile, Dorabat area under both the police.
Who is the petitioner? What's the petitioner?
Both the petitioners are the driver of the
Name?
Name Lordship Rajiv Ali and Lordship Zahid and Lordship. One
Yes.
kilo.
Yes, yes.
A team was formed, including me and self along with the team, on the above said place and one Maruti Alto vehicle bearing registration number so inside 3 persons including driver parked near at Swans Hotel in Zurabat in presence of the available witness, namely so-and-so. During search, the vehicle following items were recovered from the possession of the below noted person which were kept concealed in the said vehicle. One boat-shaped golden
Both the accused petitioners are the drivers?
Yes, sir.
And who is Mansur Ali?
Mansur Ali, Lordship, he was the passenger.
Yes, Mr. Das. 67 days. But where these you have already recovered. Do you need them for further detention? The statements have been recorded. Length of detention. Heard Mr. M. Ahmed, Learned Counsel for the petitioner. Stop. Also heard Mr. K.K. Das, Learned APP, for state respondent. Stop. This is an application under Section 439 of Code of Criminal Procedure 1973 for granting bail to the petitioners, i.e. Rajiv Ali and Jahidul Islam, who were arrested on 4/1/2024 in connection with Bukhispa Police Station case number 4 of 2024, registered under section 120B, 420, 511, 489A, 489C of IPC. Now, the case of the prosecution is that upon receiving information to the effect that fake gold currency is being transported, a team was formed including the informant of the case along with other officials, and thereafter a Maruti vehicle was stopped and searched, wherefrom one boat-shaped golden colored metal fake gold weighing 1627.0 grams within bracket 1.627 kgs, 80 numbers of 500 FICN note. What is FICN? Fake Indian currency note. So 80 numbers of rupees 500 fake Indian currency notes and 73 numbers of rupees 500 fake Indian currency notes, apart from other materials, were seized. So, Mr. Ahmed submits that the petitioners, who are the drivers of the said vehicle, were totally innocent and has nothing to do with the alleged offence. Stop. He further submits that they have been languishing in jail for the last 67 days. Stop. Mr. K.K. Das, Learned APP, on the other hand, strongly opposes the prayer for bail. Stop. He further submits that from the materials, he further submits that incriminating materials have been collected by the investigating officer. Stop. I have heard the submissions made at the bar and have considered the materials available on record. Stop. It appears that the statements of the petitioners have been recorded under section 161 CRPC. Top. It further appears that the petitioners have been languishing in the jail for the last 67 days. Top. It further appears that the fake currency notes and the fake gold has already been seized. Top. Considering the length of detention and the items having been already collected, this court is of the considered view that further detention of the petitioners are not justified. Top. Next para. Accordingly, it is provided that the accused petitioners named above shall be released on bail in connection with the above noted case with bail bonds of rupees 30,000 each. Satisfaction of learned
Chief Judicial Magistrate,
Chief Judicial Magistrate Kamrup. Conditions, return case diary, disposals of the bail application. Yes. Yes, Mr. Sharma.
Lordship.
Is there
not received? Lordship, kindly go to the page number 11. I am 86 days.
When can you have it?
Sorry, it is 86 days, Lordship.
Day after tomorrow, Mr.
86 is a
Sharma.
small thing.
Await up-to-date case diary list again on 16, 13.
Lordship, one point, Lordship.
Day after tomorrow, Mr. Sharma. 13/3/2024. Yes.
86 is only this case.
Next. Submitted.
7 days in custody. Lordship may kindly see the allegations made. Lordship may kindly see allegations made against.
Where? Page?
At page 11, Lordship. The only allegation is that, Lordship, actually the petitioner has made a victim of circumstance. The petitioner, who is an auto driver, he saw the injured person, the alleged victim, in an injured state and he took the injured on his auto to a hospital, and therefore the 20 has been invoked. And he is behind bar.
Therefore, what has been
201.
201.
Evidence tampering. Page 11 is the FIR, Lord.
Yes.
May I read the FIR, Lord?
Yes.
With due respect, I beg to submit that on 13/12/2023 at around 2 p.m. My father, Zaza Inghi, alias Rup Singh Inghi, went to Ziriginting market from our village.
You are mensing Rongpi?
Yes, Lordship. Rongmihang market for marketing and made Rajan himself Ziriginting Fangchoga.
What is there, Mr. Borthakur? Anyway, heard Mr.
Arbora.
Sorry? Arbora.
Arbora.
Heard Mr. Arbora, learned counsel for the petitioner's stop. Also heard Mr. P. Borthakur, learned APP for the state respondent. Stop. Anything else from the case diary you want to say? Because the allegation is that he... Well, I didn't really grant the bail. Yes. That is in between the other people.
Yes, Rajan.
This petitioner is Mensing Rongpi, come to on 14/12/23.
Yes,
Mensing Rongpi saw the injured. No, where did you get that? You see, then on 14, Mensing Rongpi saw the injured at the hidden place. So he was helping the injured.
Yes, Lordship.
Who is the informant here?
The informant is the son of the alleged victim, Lordship. Raza Inghi is the person, Lordship. Rupu Inghi is the informant.
This is an application under section 439 of CRPC 1973 praying for enlarging the petitioner, i.e. Mensing Rongpi, on bail, who was arrested on 15/12/2023 in connection with Zirikinding Police Station case number 17 of 2023, registered under section 302/201/34 of IPC. Stop. The case of the prosecution is that on 15/12/2023, the complainant lodged an FIR alleging inter alia that On 13/12/2023 at around 2 p.m., the alleged victim, that is the father of the informant, went to Zirkinding Market, wherein the alleged victim met one Rajan Hanse, and thereafter, while returning home, the said Rajan Hanse and the alleged victim drank together at the residence of one person. Whereafter, there was an altercation between them, wherein Rajan Hanse had physically assaulted the alleged victim, causing serious injury. One second. And by taking the help of the petitioner, he hid the alleged victim in a nearby jungle. Stop. It is the further case of the prosecution that on the next day, the petitioner noticed the alleged victim who was injured and took him to a hospital in his auto. However, the alleged victim passed away at 9:41 p.m. Stop. Accordingly, case was registered. Stop. Yes, page 16. Yes. Where are you reading from? It is this form. Oh, okay. Yes. Read. But in the forwarding report, they are saying the next day it is Rajan Hanse who took.
Yes, yes.
No, but in the FIR it was said on the next day it is Mensing Rongpi, the petitioner, who took.
Lordship, perhaps the investigating officer who had.
Mr. Bhattacharya, have you seen?
Yes, he made a mistake.
But one thing is clear that while this altercation had taken place, the petitioner was not present there.
Yes.
There is no allegation of the petitioner being present because they were three persons were drinking. Understood. But Mr. Bhattacharya, just answer one question of this court. You see, in the FIR, it is clearly mentioned that Rajan Hanse and the deceased went to some other house where they were drinking, where there was an altercation. Correct? Thereafter, something has happened, and then, with the help of the petitioner, he was hidden. The role of the petitioner comes later. So, is that correct as per the statement? Because if that is true, then we will grant him bail. Otherwise, we will not. From the statement that you read, does it indicate that he was present at the time of altercation? That time he was not there. That is what. Correct. His role is only to, as regards hiding. Mr. D. Gogoi, Learned Counsel for the petitioner, submits. Mr. R. Bora, Learned Counsel for the petitioner, submits that on 13/12/2023, the deceased and Rajan Hanse were drinking liquor at the residence of one Uttam Pansu, and both of them, after engaging in verbal and thereafter there was a physical altercation. Stop. The petitioner who was driving his auto towards his home noticed the said altercation and stopped his auto in front of the residence and tried to stop the altercation and made both of them understand. Thereafter, he left the residence of Uttam Panchu and moved towards his residence as it was already dark. Stop. On the next day, when he was going towards market in his auto, he saw the alleged victim in an injured state near the jungle and immediately took the alleged victim to hospital in his auto. Stop. However, by the time they reached the hospital, the victim was declared dead. Stop. Mr. Borthakur, learned APP, on the other hand, strongly opposes the prayer for bail. Stop. He submits on the basis of the materials available on record that the petitioner has helped the accused petitioner, what is his name? Rajan Hanse. Has helped the accused Rajan Hanse to hide the injured deceased and thereby causing death. Stop. Correct? Because of the delay. Stop. I have heard the submissions made at the bar and have perused the materials available on record. Stop. How many days?
87 days.
57?
87.
87. And statements recorded? Charge sheeted. He further submits that in the meantime, charge sheet has been submitted by CS number 120-24, dated 8/3/24. Stop. After the perusal and all that, huh? It appears that the petitioner has been languishing in jail since last 87 days. Stop. It further appears that the investigation has been completed. Stop. Considering the length of detention, this court is of the considered view that further detention of the petitioner is not justified. Stop. Accordingly, it is provided that the petitioner named above shall be released on bail in connection with the above noted case with a bail bond of rupees 30,000, satisfaction of
JMFC West Karbi Anglong.
Judicial Magistrate
First class.
West Karbi Anglong
at Hamrin.
Hamrin. Investigation to Huigul Learned Trial Court. Appear before the Learned Trial Court on all dates and inducement. CD returned. Which CD has not come. This disposes of the bail application. Yes. Cornali, something is wrong with my PC. It's not on. So they're trying to on it. Till then, let me take up another. What is joke? No, what is 34?
Please, Your Lordship.
Yes.
This is the 438 application. Charge sheet.
PD, Mr. Borthakur.
Scanned copy of the record has been.
It has come. Have you gone through?
My Lord will find the FIR at page 14, my Lord.
Page
14. In this case, the informant and the petitioner.
Mr. Nawaz, page?
Page 14, my lord.
14.
14. The petitioner and the informant were having an affair. In the course of the affair, the informant eloped. 2 days thereafter, my lord, the informant's husband goes and recovers the informant. Thereafter, the informant comes and lodges the FIR. My lord, if I may read the FIR.
Yes.
Sir, the informant humbly submits that I am a permanent resident of the aforementioned address and approximately 1 year.
Are you on interim?
No, my lord.
Yes.
I am a permanent resident of the aforementioned address. Approximately 1 year ago, I married Mr. Such and Such, son of Such and Such. The incident in question occurred on 11/2020 at around 1 p.m. during my husband. The accused person illegally trespassed my husband's house, and by engaging me in enticing conversation, he expressed a desire to take me out to the Gosaigao railway station. Subsequently, he forcefully confined me in an auto rickshaw, kidnapped me, transported me to Shirampur, and from Shirampur he took me to the village of Tolbari Nagar Hat in the Coach Bihar district of West Bengal.
Yes, Mr. Parashar? So she went on her own. No force, she doesn't say anything. So she is not corroborating her FIR statements then. That she says in her 164. For trafficking. That means she has corroborated her version narrated in the FIR. Sorry, Mr. Nawab.
My lord,
Nawaz.
If I may submit, my lord, 2 things.
No,
First of
we've
all,
seen it and we've heard the PP. What else?
My lord, the petitioner.
This is not a case for anticipatory bail.
My lord, the informant in this case, he claims that she was transported from Gosaigao through public.
We will not be microscopically examine the averments in the FIR at this stage.
In this case, my lord, is that
Sorry.
charge sheet has been submitted. My lord, there's one humble prayer.
Yes.
Now, the charge sheet has already been submitted. Now, there are issues, my lord, in the charge sheet also. She has refused. It's clearly stated that she has refused medical mind. But we could raise this issue. That is, there specifically stated that she has refused to undergo medical examination. Now, my lord, we could raise this issue before the learned court also.
In any case, she is already a married woman.
Married woman, my lord. So,
all right. Heard Mr. Safraj Nawaz, Learned Counsel for the petitioner. Stop. Also heard Mr. KK Arasar, Learned APP for the state respondents. Stop. This is an application under section 438 of CRPC 1973 praying for granting anticipatory bail to the petitioner, i.e. Monty Roy, who is apprehending arrest in connection with PRC number 116/2023 registered under sections 366, 376 IPC 1860. In connection with Gosaigao Police Station case number 69 of 2020, registered under sections 342, 448, 420, 360, 376 of IPC. Stop. The case of the prosecution is that on 11/2/2020, while the informant's husband was absent in the house, the petitioner illegally trespassed into her house, and by engaging her in enticing conversation, he expressed a desire to take her out to Gosaigao railway station. Stop. Subsequently, he forcefully confined her in an auto rickshaw, kidnapped her and transported her to Shirampur, and from Shirampur he took her to the village of Palbari Nagar Hat in the Coach Bihar district of West Bengal, and thereafter he brought her to an associate's house where they spent the night. Stop. It is further alleged that in the night he forcefully restrained her, tied her hands against her will, and raped her. Stop. It is further stated that she overheard a conversation of the petitioner with a woman trafficker over the phone to sell her. Stop. Accordingly, a case was registered. Stop. Mr. S. Nawaz, Senate Counsel for the petitioner, submits that the
My plea is at page 5, para 8.
submits that the actual facts of the case are that over the course of the past 2 years, the accused petitioner and the informant shared a relationship extending beyond mere friendship. Stop. He further submits that the petitioner and the informant engaged in regular communication and had contemplated eloping and living together. Stop. However, several days prior to their elopement, the informant expressed a desire to cohabit with the petitioner. Stop. Together they don't say together. He further submits that as per the set plan, she on her own will had gone with the petitioner. Stop. Mr. K.K. Parasar on the learned APP on the other hand strongly opposes the prayer for bail. Stop. He further submits that it appears from the statement of the informant recorded under section 164 CRPC that she fully corroborates the version given in the FIR. Stop. He further submits that she clearly implicates the petitioner of the alleged offence. Stop. Next para. I have heard the submissions made at the bar and have perused the materials available on record. Stop. Then you see. It appears that there are sufficient materials on record implicating the petitioner. Stop. As such, this court is of the considered view that the petitioner has not made out a case for release on anticipatory bail. Stop. Accordingly, prayer for anticipatory bail at this stage is rejected. Application sent to post office.
Deeply obliged.
Mr. Mehta, Mr. Chaudhary, are you ready?
Yes.
Yes, what has happened?
No, my lords, I have filed this interlocutory application, my lords, which your lordships have been kind enough to have it listed today, my lords. What has happened was this, my lords. Your lordships knows, my lords, the sequence of my lords, the hearing in this matter, my lords. 26th February,
Mr.
your
Mehta,
lordships.
is it correct that the prize bids have been opened?
I'll just point out, my lord. Lord, this is.
Yes, because during mention, admission was made that the prize bids have been
was
opened. Is that correct?
Possibly a misleading mention. I'll point out why. Lord, there are
You are
109.
Your voice is not very clear. The same voice is not.
Am I audible now? Give me your laptop. I'll just join
Yes,
from
Mr. Mehta?
another device, my lord. Am I audible now, my lord?
Yes.
Yes, you are.
Lord, there are 196 clusters throughout the country. Your lordships have seen, my lord, the position of clusters. But the present petition pertains to 7 clusters. Correct?
In respect of which we have passed an interim order.
And there we have not done anything. We cannot do anything, my lord. We are bound by the court's order. With regard to other clusters, my lord, which is in the Calcutta zone, not zone, but Look, there is some word originating from Calcutta. There are some other tenders which are not subject matter of this challenge in this petition. He says that since the all amounts to disrespecting the court.
There is some problem at your end, Mr. Mehta. You're still not very clear.
Oh,
However, Mr. Chaudhary,
Yes,
Mr.
my lord.
Chaudhary, are you there?
Yes, my lord. Yes, my lord.
Mr. Chaudhary, if I recollect, on the very first day when you had moved the interlocutory application, we had made
Yes,
it
ma'am.
subject to the outcome of our decision, correct?
Yes,
At that
yes,
time,
ma'am.
you had given those numbers of the tender numbers, which were
Am I now audible, Manoj?
petition, correct? Now,
Yes, my
only
lord.
in respect of that, this court has ordered that price bid shall not be opened without leave of the court.
And they are
That
not
they
open.
have not done. Where is the occasion for this? The matter is already concluded.
No,
It's reserved for judgment.
my
This
lord.
is in respect of some
Let
other
me say.
tenders. That is not.
Yes,
matter.
Manoj, yes.
Circular could be, but the first order, which has been passed by this court in your IA, was in respect of, I think, 7 or 8 tenders, if I'm not wrong. And I
7,
think so,
your lordships
correct?
have mentioned the numbers also.
That numbers was given by you, Mr. Chaudhary, if I recollect.
Yes, my lord, and they are not, my lord,
Let my
open.
lord conclude. My lord.
There are, my lord,
May I say something?
Yes,
109.
I think Mr. Mehta can come back again. Yes, Mr. Chaudhary.
Yes. No, my
Please
lord,
clarify the position.
Yes, my lord. So when initially the writ petition was filed and moved on 22nd January 2024, my lords, Justice Barua's notice, my lords, notice of motion. That day, my lords, these tenders, my lords,
It was
what had
said that
happened?
you can file an IA. Then you
Yes,
file
what
an
had
IA.
happened was
And we've passed
my
an order in that IA.
yes, my lord, my challenge, my lords, was to the circular of 14th November 2023, my lord. That circular was under challenge. Thereafter, my lord, what is happening is when the matter is pending, they are issuing tenders. Now, what happened, my lords, is that on 22nd of February 2024, at that stage, my lords, there was only the bids regarding 15 clusters which was received on 22nd. So your lordship stated, my lord, that those 7 numbers which we readily had, my lords, we gave it to your lordships in an IA. Your lordships observed that this will be subject. Now, my lords, 26th of
Correct.
February.
And later on, when we saw that the hearing is not going, is likely to take some time.
Yes.
In the interest of justice, we said no price bids in respect of those tenders.
Let me just say.
Now we can't pass a blanket order.
Some other
Already
cluster,
heard.
my lord, some other cluster. And my lord, petitioners have not even applied in that tenders. They are not tenderers in that tender.
We are not eligible, sir.
That is, you are
No,
not
let's-
you are not eligible in this also. But
No, let's-
that is completely
Sorry, but I'm not
foreign
inclined
tender.
to give more time to this. I have a lot of other matters on board today. This matter is otherwise reserved, and apparently this is not relating to the tenders which are subject matter. Undoubtedly, the circular, that condition itself is under challenge. There's no doubt about it. But you confined it on the first.
Just permit me to present it. Thereafter, I'll leave it to your lordship, my lords. The hearing, my lords, which started, my lords, initially the challenge in the writ petition was to the circular. Then, my lords, on 22nd, there were bids received. So 22nd, your lordship said these 7 bids, 22nd of February. 22nd February. Yes. 22nd February, your lordships had fixed the matter on the interim application. When your lordship said that I will hear the matter finally. So on 22nd, your lordship said that these tenders which were then issued, my lords, at that stage will be subject to the outcome. Now, my lords, what happened is after 22nd, my lord, 26th matter was fixed. I concluded my arguments on 26th. Now on 26th, your lordship fixed the matter on 4th March 2024. On 4th March 2020, between 26th and 4th, on 1st March, my lord, they received tenders for a further 11 clusters on 1st March.
They received
tenders for a further 11 clusters on 1st March. Unconnected clusters.
Tenders must have been issued earlier.
But there are total 196 clusters. All
my lord,
India.
The entire policy is under challenge in this writ petition. Now, my lord, between 26th, when I concluded my argument, and on 4th March, I had informed your lordships when my lord, time was sought for my lord, on behalf of the respondents to conclude the argument, to start the arguments on 4th March. 4th March, your lordship said, please have the order at page 26 of my IA, my lords. Your lordship stated since the matter is, since
In any
hearing has
case,
started.
what we can do, Mr. Mehta and Mr. Chaudhary, we are not going to go into the price bid part, but we can say that any bid opened in connection with the impugned circular shall be subject to the outcome of this writ petition. We can say that. Because at the end of the day, that circular, if goes, then all the NITs in connection will also go, isn't it?
Just give me
just
give me 60 seconds. Just give me 60 seconds by the clock.
Yes.
Sir, just 60 seconds, sir. After that, sir, you'll have the.
Yes, Mr. Chaudhary.
No, we are before the court. Our court will.
No.
We can't allot it.
My lord, on 4th March, your lordship stated, my lord, since hearing has started on 4th March. Now, my lord, what happens is this: matter is fixed on 7th March. 7th March morning, 10:30, they open the price bid relating to the same impugned circular. And that is not even informed to your lordships on 7th March. Matter is argued.
Yeah, what is this?
My lord, matter was argued, my lord, on 7th March.
We will not get into all that because that circular had a lot of NITs. Now,
196
subject to the outcome because those NITs
my
were
lord,
not infringed.
my lord, it was
already been closed.
I leave it. Can I speak now, Mr. Chaudhary?
Any NITs issued in connection with the impugned circular shall remain subject to the outcome of this.
Can I, my lord, say something?
No, we will make it clear because if the...
No, my lord, allow me to say something. My lord, allow me to say something.
Condition, it will have its implication in all.
My lord, allow me to say something. My lord, allow me to say something.
Yes,
My lord, this is an all India circular where the total NIT all India, where your lordships have seen that 2 high courts have upheld the validity of this particular circular. Your lordships can uphold, your lordships may not uphold. That's entirely your lordship's discretion. I'm not citing those 2 judgments as a binding precedent. But not any cloud being created at the instance of few individuals at an all India level would affect the price bid. Is he ready to compensate me? The price bids would either be less in number.
I'm not going to the price bid part. I've already made it clear because.
My lord, I am saying, my lord, somebody in Madras. My lord, only give me a minute. My lord, give me a minute, my lord. Somebody in Madras, having come to know that this entire issue is in challenge and my bid is going to be subject to something, my lord, he may either not bid or may bid something less. My lord, null and void. Your lordship saying it will make it worse.
We can't hear you.
So your connection is.
Mehta, this court cannot hear you.
Lord, now your lordships can hear me, Lord. Am I audible, my lord, now?
One clarification: those 7,
my lord, it my lord, may not.
Which we made subject to.
My lord, your lordships have not.
Those 7 NITs that we had made subject.
My lord, your lordships have not heard me.
Subject to the outcome. Those NITs are related to which place?
Your lordship have not heard me, my lord. I am not audible, my lord. Am I audible? Now am I audible? My lord, out of 126 clusters, the petitioners have applied for 7 clusters, which are the subject matter of this writ petition, which your lordships, my lord, said that no price bid to be opened without leave of the court, and it is not opened.
What do you mean by the petitioner has applied? Has they submitted bids for the 7 NITs? They cannot qualify.
Applied before your lordships. Applied before your lordships with.
You are saying that they have confined it to 7 NITs in the writ petition?
Yes. Mr.
All over India.
Now what he says is, in case of some other cluster, we have opened the bids which are not the subject matter of stay by your lordships. Lord, we have several clusters, several tender notices in the entire country, and the total is 196. If not set aside the commercial circular, the consequences will follow. But your lordship saying that this would be subject to the outcome, Lord, people may not come. Your lordships are aware of the law on the point. then, my lord, he will have to compensate me. Let him deposit, my lord, the amount to be fixed by your lordships, my lord, in case the state government loses, the railway loses.
Let me do one thing then. Let me not pass any order in this. I'll keep it along with the others and I'll see what is to be done.
Correct, my lord, bilkul. And your lordships may decide, my lord, this is completely. He says, in Calcutta division, some price bid is open. He is concerned with, my lord, in Calcutta division, my lord, he could have gone to Calcutta High Court. The way, my lord, they are traveling all over the country, my lord, Ranchi, Karnataka, they could have as well gone to.
I will pass the order.
May I just say something, Malad? To peg down this writ petition to 7 NITs, Malad, is not correct. Please have my prayer at page 44, Malad. That at that time when the challenge was made, Malad, the challenge was to the policy and all consequences.
The policy, entire all India policy is not stayed by the court.
Malad, 2 clusters are there, Malad. Now, Malad, what I am saying is, Malad, at least they should have held their hands off or otherwise informed this court, Malad. On 7th, Malad, a full-fledged hearing
argument of prejudice, not
without informing your lordship, Malad. That was it was my duty to bring to your lordship's notice, my lord.
Third, Mr. A. Chaudhary, Learned Counsel for the assisted by M.S. B. Chaudhary, Learned Counsel for the applicant. Top. Also heard Mr. T. Mehta, Learned Solicitor General of India, assisted by Mr. Mr. K. Gogoi. Stop. And Mr. A. Anik Singh for respondent number 5. Stop. This application has been filed in WPC 317 of 2024, wherein after completion of arguments, matter has been reserved for judgment. Stop. The grievance of the petitioner is that, of the applicant is that, pursuant to the...
Lord, I'm sorry for the interruption. Is your lordships considering any order, my lord? I'd like to...
No, I'm not. Mr. Please...
I'm sorry, my
apologies. Mr. Mehta.
My apologies.
The grievance of the applicant in this interlocutory application is that pending hearing of the subject writ petition, financial bids was opened on 7/3/2024 in connection with other cluster bids. Is it called cluster bids?
Yes, my lord. He has selected 2 tenders, my lord, but there are total 196.
I1, Roman 1, Roman 2, you will get the details in paragraph 12, in page 12. However, at the time of then you say that be that as it may, in the writ petition, which is reserved for judgment, this court by order dated, is the first order whereby
22nd February. 22nd February 2024.
22nd to 2024 has directed the NIT bearing numbers 1, 2, 3, 4, 5, 6, 7, right? 7 shall remain.
Para 3 of the application has the numbers. Just for assistance. Para 3, page 5. Subject to being corrected by Mr. Chaudhary, my lord, I'm relying on his application.
Yes, it is there at para 5. Shall be subject to the final outcome of the present writ. Subsequently, since hearing could not be completed on 4/3/2024, this court by order dated, next order date?
No, 4th March, para 6.
4/3/2024, directed that the prize bids in respect of the aforesaid 7 NITs
Correct.
shall not be opened without the leave of this court. Stop. Finally, the arguments were completed on
7th March.
7th March, my lords.
7/3/2024, and the same was closed for reserved for judgment. That being so, no orders as of now is called for in the present interlocutory application. Stop. The same is tagged with WPC number 317 of 2020.
Grateful. Dear.
Otherwise, both are standard. Both are standard. To beat, they are standard.
And this is northern.
Northern. This Southeastern Railway, which was Lordship has indicated Southeastern Railway, the beat which they mentioned Eastern Railway.
That is Eastern.
Eastern Railway.
The two, okay, relating to Eastern Railway.
Eastern Railway.
And this one is?
Lordship has directed Southeastern Railway, SCL.
Southeastern.
Southeastern.
Thank you.
Apologies.
My pleasure.
Yes.
Here the petitioner and informant are cousin brother resident of the same village adjacent house, Your Lordship. If I resident at the same
is ID?
Is there received, madam?
Resident of same village with adjacent house, Your Lordship, cousin brother by relation is number 8, Your Lordship. The FIR, Your Lordship.
Page number?
8. Actually, both are work as a mason, Your Lordship, in Guwahati, Your Lordship, construction site. Thereafter, together delivered them rupees 21,000, and my 50% share is 10,500. That was denied by the informant.
Yes.
Yes. So initially, he asked for an amount of rupees 10, and thereafter, while my lord
snatched away 10,000.
Refused, he snatched an amount of rupees 10,000 and he's moved. Who's moved?
Also, Your Lordship, and
was he on interim? No.
No interim. Regarding recovery, there is nothing in the case.
He has to pay rupees 10,000 to me as my remuneration. Your Lordship.
Let him then
yes.
appear. He hasn't appeared till now.
No.
Let him appear.
Yes.
Your name?
A.A.R. Karim.
Heard Mr. A.A.R. Karim, learned counsel for the petitioner. Top. Also heard Mr. P. Borthakur, learned APP Assam. Top. This is an application under 438 CRPC seeking pre-arrest bail in favor of the accused petitioner, i.e. Sri Sahinur Ellis Sahinur Islam, who is apprehending arrest in connection with Dhubri, within brackets Sador, PS case number 437 of 2023, registered under section 392 IPC, corresponding GR number 1759/2023. The case of the prosecutrix is that, the case of the prosecution is that on 20/10/2023, while the informant was going to deposit rupees 10,000 at CSP means Central
Customer Servicing
Point.
At the Central Servicing
Customer
Servicing Point of Gazibur Rahman, the FIR named accused person, i.e. the petitioner, prevented him and asked him of rupees 10, but he denied to give him, he said, money. Stop. As such, it is alleged that the petitioner entered his hand in the informant's pocket and snatched away of rupees 10,000 and a mobile handset. Stop. As such, a case was registered. Stop. Mr. A.A. Karim, right?
Yes.
Mr. A.A. Karim, learned counsel for the petitioner, submits that the informant. There are how many petitioner? One.
Only one.
That the informant, that the petitioner and informant are day laborer by profession and are related.
Cousin brother.
And are related to each other. Stop. He further submits that few months earlier, both the petitioner and the informant worked together as day laborer, wherein balance amount of remuneration of rupees 21,000 was to be payable by the contractor to both of them equally. Stop. However, the informant received the said balance remuneration of rupees 21,000 without informing the petitioner, and accordingly some altercation had taken place between them with this regard. Stop. On the next para, Mr. P. Borthakur, Leonard APP, submits, opposes the prayer for anticipatory bail. Oppose? Stop. I have heard the submissions made at the bar and have perused the materials available on record. Consider he further submits that the petitioner is willing to cooperate and appear before the investigating officer. Now you write. Considering the facts and circumstances of the case, it is provided that in the event of arrest, the petitioner named above shall be released on pre-arrest bail in connection with the above noted case on furnishing bail bond of rupees 20,000 with one surety of like amount to the satisfaction of the arresting authority, subject to the following condition. Number one, appear investigating officer, 7 days, inducement, refrain. This disposes of the anticipatory bail application. Return case. Yes, case diary.
Yes, my lord.
Yes.
The petitioners are on interim relief, and as per my instructions, they have appeared before the investigating authority.
Yes, Mr. Borthakur.
Yes, my lord, appeared, statement recorded, and my lord, injury report also received. Injury report simple, my lord.
Simple?
Simple by blunt weapon.
Okay. Right. Heard Mr. Esra.
M.H. Loss.
Heard Mr. M.H. Lockor, learned counsel for the petition. Lockor, learned counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, learned APP for the state respondent. Stop. This is an application under section 438 of the CRPC seeking pre-arrest bail to the petitioners I, 1, 2 and 3, page 3, who are apprehending arrest in connection with Gauripur PS case number 486 of 2023, dated 30/12/2023, lodged under sections 325, 307, 379, 34 IPC. Stop. It would be pertinent to mention that by order dated 9/1/2024, the aforementioned petitioners were granted interim pre-arrest bail. Stop. The case diary called for is placed before this court. Stop. Mr. P. Borthakur, learned APP Assam, submits that the petitioners have recorded that the petitioners have appeared before the investigating officer in terms of the order dated 9/1/2024 passed by this court. Stop. He further submits that their statements under section 161 of CRPC has already been recorded. Stop. He further submits that the injury report indicates that the injuries sustained are of simple in nature. Stop. Considering the above, this court is of the considered view that custodial interrogation of the petitioners are not necessary for the ongoing investigation. Stop. Accordingly, the interim pre-arrest bail granted by this court by order dated 9/1/2024 is hereby made absolute, subject to the following conditions. Number 1, corporate investigation. Return case diary. This disposes of the anticipatory bail application. Yes. Next. Yes.
This 438 application, petitioners are on interim mailer, and he appeared before the IO.
Yes, case diary.
Yes, case diary received, my lord. There
Yes.
are materials, my lord, against the accused person. My lord.
There are?
There are incriminating material against the accused person.
This is that misappropriation.
Yes, my lord. He, at the time, while he was the president of that Samobai Committee, my lord, and accused number, here only one petitioner, my lord, accused number 1, along with one another secretary of that Samobai Committee, misappropriated an amount of rupees more than 22 lakhs, my lord. And my lord, this is, your lordship may kindly peruse the present. Till now they have not recovered, my lord. Your lordship may kindly.
What does the accused petitioner say in his statement? He appeared, right?
Statement recorded, he appeared.
He admits. This money is in whose account now? Misappropriated and transferred to whose account?
So, my lord, question is
Mr. Ahmed, you are appearing for?
I am appearing for the informant. Here in this case, Lordship, this is not a case of misappropriation. Here what happened, Lordship, even if your Lordship see the interim order, they obtained the interim order saying that in the year 17-18 there was an audit report which says the money was adjusted. That audit report itself was under inquiry, Lordship. They never participated in that inquiry. Subsequently, by showing that inquiry report, they have obtained the interim order. And they say, Lordship, that money which was misappropriated was adjusted in subsequent years. But in subsequent years, audit report nowhere shows that that was adjusted. They were doing, Lordship, misappropriation and the forgery, Lordship. Because of that, I am for your Lordship.
Amount is 22 lakhs.
22 lakhs. Had it been a simple case of misappropriation, I would not have Lordship objected. But the case is that they are manipulating documents to show place before this court and before the authorities. When authorities are, Lordship, trying to inquire into the matter, they are not cooperating with those authorities.
They are not cooperating, Mr. Bhattakur?
Regarding that audit report, there was an inquiry, Lordship. They have never appeared before that department.
Mr. Bhattakur?
Otherwise, my lord, he appeared, statement recorded regarding, my lord, there is no such note IO has stated regarding that he has not cooperated with the investor. There is no such note. But, my lord, in his statement, my lord, in fact, he admitted that some of the money is in my pocket. That, my lord, because, my lord, secretary and the president both are involved in collecting.
Yes, now the question is whether further custodial interrogation is required.
Because, my lord, till now they have collected such a huge amount from the shareholders, and till now they have not returned that money, my lord. In fact,
keeping him in the jail, you think they will return this money?
Your lordship,
tomorrow they are held guilty, they will suffer the consequences.
I will leave it to your lordship, my lord. Otherwise,
sure. It will Anak Moitri.
Your lord, the present position. Your lordship may kindly peruse this page and also the balance sheet.
You are Lutufur Ahmad?
Yes, Lutfur
Rahman. And who is Sohidur Rahman? He is not before this court?
Secretary of the.
He is not before this
court. He is
court.
not before us.
And which is the other thing you wanted me to see, the balance sheet?
Yes, my lord. Balance sheet is also that, my lord, that money he has not returned that amount. Till now, that in his pocket, in his statement
So
also.
investigation is at a crucial stage.
Yes.
You see the paragraph 4, they are trying to say that in their bail application that it was adjusted. It was never adjusted.
My lord, can you
That
just
paragraph
peruse
4 of their bail application.
page 22, my lord.
Page
22. This is the audit report of 2017 and 18, my lord. And the vernacular is at page 24.
Yes, I've seen. And which is the other page you want
Paragraph
court
4
to have a
Lord
look?
Chief,
Paragraph?
Paragraph 4.
4.
4 of their bail application. They are trying to say that that was adjusted, but that was
Yes,
never adjusted.
yes, clearly stated in the audit report.
And regarding the
That the materials collected by the IO doesn't indicate that this money has been adjusted. Correct,
Yes,
Mr.
my lord.
Watergard? It shows it is yet to be recovered.
No, my lord, the audit report is clearly said, my lord.
There was an inquiry hit
My lord,
time to
audit
appear.
report
What is
clearly
this?
said.
Who has given this?
I have given.
What is this?
He was directed to appear before the department regarding that audit report which he had placed. And he took time to appear before the department. He never appeared, and therefore, regarding that genuineness, there was no.
All right. You take your seat. Yes, Mr. Bhattakur.
My lord, just.
Yes, my lord. Now I will leave it to your lordship because those are the materials I am placing before your lordship on the basis of the case diary.
Only thing is this money has not yet been recovered.
Yes, not yet recovered.
What about the other
his
person?
submission is that already that money adjusted.
Have you apprehended
that is not-
Sohidur Rahman?
Lutfur Rahman, yes.
No, Lutfur is the petitioner.
Petitioner.
Correct. What about the other
Other
accused?
accused was
He is also
because,
on interim, my lord.
He is not before us.
He has his statements recorded.
His statement, my lord, I have not gone.
My lord, what had happened in
One
this?
second.
My lord, what had happened in this?
1 second.
Yes.
I will find out.
Doesn't appear that his statement is here. Any adverse report as regards his antecedents?
Regarding my lord, antecedent, there is no, sir, because this
Fleeing
is
from justice? Any apprehension that the IO has not given?
regarding that there is no such. But
In item 39. Heard Mr.
Arson.
R. Islam, stop. Also heard Mr. P. Borthakur, learned APP for the state respondent, stop. And Mr. A. Ahmed, Mr. A. Ahmed, learned counsel for the respondent number, for the informant stroke respondent. This is an application under section 438 of CRPC for granting pre-arrest bail to the accused petitioner I. Lutfur Rahman, who is apprehending arrest in connection with Mankasar PS case number 431/2023, registered under section 403, 406, 409, 468, 34 of IPC. So, the case of the prosecution is that it is submitted or pra. On the last occasion, Mr. Bhattakur, Mr. Parashar had made a submission that from audit report it appears this money has been deposited. But that the case diary doesn't say that.
yes, that audit report also, my lord, that is, my lord, the recent report I placed before your lordship.
This
From that-
says
from
this
that,
money
my lord,
is yet
not
to be recovered. Correct.
Yes,
Fresh report of recoverable amount.
yes. Recent report of
have not been recovered, it says.
Yes, not yet recovered.
But in the audit report 2018, 17-18, what clearly said that it is seen that the said amount was realized in the financial audit of the following year 2018.
Then you say that it may be mentioned that in terms of the that in view of the submission made by the office of the additional PP, that the money has already been deposited by the petitioner as evident from the audit report. This court, by order dated 5/2/2024, granted interim pre-arrest bail to the petitioner. Stop. Mr. P. Borthakur, APP Assam, submits that the petitioner has appeared before the investigating officer and his statement has been recorded under section 161 CRPC. Stop. He further submits that there are incriminating materials available in the case diary implicating the petitioner. Stop. Then change the Tara, right? I have heard the submissions made at the bar and have perused the materials available on record. Stop. It appears from the case diary that as per report of the inquiry officer, rupees 11,17,986.00 and 28,112.00 have not been recovered from the petitioner and the co-accused. Stop. It further appears that the investigation is at a crucial stage and Stop. In view of the above, this court is not inclined to grant anticipatory bail to the petitioner at this stage. Stop. Petition for anticipatory bail accordingly stands rejected. Case diary returned back. Disposals of the application.
Just 1 minute, one thing.
Order has been passed, Mr. Counsel.
I just
Yes.
point out, my lord, there is a case, my lord, in the writ petition, my lord, they have removed, filed the FIR
That's
in
all
the
right.
capacity of chairman, but not in the capacity of chairman.
Itu gimana person? Disposed of them. Yes.
438 application lordship. He is on interim lordship, and as per my instruction.
Case diary?
Yes, case diary received.
Yes, what is your instruction, Mr. Ahmed?
As per my instruction, he appeared before the investigating officer and cooperative. Here, your lordship is on FIR at page 8. Here, what happened, lordship? After enactment of new acts, lordship, there was a ban declared by the drivers' association, lordship. The petitioner is neither a driver nor member of that association. On the very day, lordship, he was going to purchase medicine for his wife, lordship. He was at the spot, and at that moment, this incident occurred, lordship. And thereafter, police named him as an accused in the FIR, lordship. And some of the other accused persons are also interim bail, lordship. I have enclosed their interim orders.
Is there anything against the petitioner?
My lord, fact is that there are several persons, there are photographs also in the road. Some person snatched the base of the police person. That was there.
Any role attributed to him?
My lord, no. Directly,
there is no role.
He was in the mob, my lord. Photographs is there, my lord.
He was on. His statement has been recorded.
Yes,
He's already cooperating. All right.
He appeared, my lord, on 22nd of February.
Heard Mr. A. Ahmed, Learned Counsel for the petitioner. Stop. Also heard Mr. K.K. Parashar, Learned APP for state respondent. Stop. This is an application under section 438 of CRPC for pre-arrest bail to the accused petitioner, i.e. Abdul Rakib alias Rakibuddin, who is apprehending arrest in connection with Bozorichhara Police Station case number 6/2024, registered under section 147, 148, 149, 152, 341, 353, 307, 332, 392, 436, 511 IPC. Now, the case diary call for has been placed before this court. Now, it may be mentioned that that by order dated 15/2/2024, only one clarification, Mr. Since this interim bail was earlier considered by another bench, this
rotation basis. One of the interim bail order was considered by your lordship. That page can your lordship.
In case of dispose of and allow or rejected, then
that in that case, all right. This court had granted the petitioner interim pre-arrest bail. Stop. Mr. Next para. Mr. K.K. Parashar, learned APP, submits that the petitioner has appeared before the investigating officer in terms of the order dated 15/2/2024 of this court. Stop. He further submits that the statement under 161 CRPC has already been recorded. Stop. He further submits that the investigating officer has not collected any incriminating materials as against the petitioner. Stop. Considering the above, this court is of the considered view that custodial interrogation of the petitioner is not required for the ongoing investigation. Stop. Accordingly, the interim pre-arrest bail granted earlier by order dated 15/2/2024 is hereby made absolute, subject to the following conditions. Number 1, corporate investigation. Number 2, inducement. Return case diary. This disposes of the anticipatory bail application.
He is on interim but CD not received.
Await CD list on
from Nagaon, 2nd of April, my lord.
Await CD list on 2/4/2024 interim, if any, shall continue till then.
42 charge sheet submitted.
On interim? Charge sheet submitted?
My lord.
Let him appear then.
My lord.
Lordship, allegation is lawsuit. More particularly against the lordship. Page number 9 may kindly be looked into, lordship.
You appear before the trial court. Charge sheet has been submitted. This is item 42. Heard Mr. A. Diwan, learned counsel for the petitioner. Stop. Also heard Mr. K.K. Parashar, learned APPs for the state respondents. Stop. It is submitted. You say Mr. K.K. Parashar learned APP submits that charge sheet by CS number 266/23 has been dated 31/12/23 has been submitted in the case. Stop. In view of the aforesaid submission, this court is of the considered view that let the petitioner appear before the court of
Subdivisional Judicial Magistrate North Salmara of Haipuri.
Before the court of Subdivisional Judicial Magistrate North Salmara of Haipuri within a period of 15 days. Stop. Disposes of the application.
Till then you must protect.
Till then. Yes. Till then protection. That same order. Yes, Mr. Chaudhary?
Yes, my lord, the allegation, kindly see, my lord, frivolity of the allegation, page 13.
Yes.
My lord, after more than 2 years, this affair has been lodged.
Yes.
I, Preeti Thapa, is a 21 years daughter of so-and-so of Lam Road.
Were you on interim? No.
Yes. No interim. No interim.
Yes.
Yes. And me were schoolmates, but later I was forced into relationship with him. During the days of my relationship with him, his entire family forced me to so and so, so and so. They started to threaten me by spoiling my life. Parvez Ansari also used to beat me up publicly and burn my hands with cigarette if I refused to read the Quran. I was also working during so and so, so and so. On 4th of January 22, Parvez Ansari, through a common friend, Subham Santi, brought me to Rajdhani guest house near so where he and got physical with me. That day also he was threatened me to get converted to so, and when I refused, he physically abused and forcefully got physical with me the entire night after I refused to accept his. Hardly within that period of a relationship on March 8, 22, I got my ultrasound scan where I was reported to be 1.5 million and I was 20 years old. After telling them that I got pregnant, they falsely promised that.
Yes, Mr. Parashar?
Yes.
Can I just place one more thing? It appears to be very serious. Now, my lord will kindly come to page number 22. My lord, I am not denying the relationship part and the other things. Kindly see, my lord, my parents took care of her.
Page 20?
Page 23 onwards. These are the money which I paid to her. My father paid, my lord, for her treatment, for her student education, everything. Now, after 2 years, my lord, this has been filed. This FIR has been filed. Kindly see, my lord, up to page 32. I am not disputing that, my lord, relationship.
Why this money were paid to her?
Money was paid, my lord, first for getting the child, number one. In Delhi it happened. And
But
secondly, for pursuing her studies, my lord.
These payments were when? Made 23?
Yes. 21 onwards, my lord. 21 is a recent amount on 24/11/23.
Why was the payment given? For the
for my lord,
maintaining the child? The child is born.
Something like maintenance, my lord. Something like maintenance. My lord, question is, where is the element of that offence? It was a consensual thing.
Later he refused.
Later. No, it's not that we refused or something, my lord. Even the child was given to some adoption center child was given. Then she had some relationship with another boy.
But the allegation is that he refused to marry her later on.
Yes.
And he had to go for higher studies outside.
Yes, in fact, now I am pursuing I just passed my 12th and I am undergoing my training, coaching, my lord.
Is someone appearing for the informant? Huh, Mr. You are there? Yes. We will come back to it. Mr. Parashar?
My lord, here, my lord, 161 statement is very elaborate, but subsequently 164 also there, my lord. 3 pages 164 statement. Thing is that, my lord, yes, they have relation since the time of education, they are classmates. And day by day relationship grew, my lord. Subsequently, on one day, my lord, she was called to one of the co-friend, my lord. And at that point of time, she refused to go. And she earlier also said that as the community are different, my lord, so Mary is not a, my lord, maybe there will be a problem, my lord, that is there. And on that day she refused. Then he threatened that if you will not come, there are some photographs, intimate photographs are there, I'll make it viral. Then ultimately she went on that night to a lodge. And on that night, my lord, she was forcefully supposed to drink.
This was 2 years back.
Yes, alcohol is there, my lord.
That's 2 years back.
Yes. Thereafter physical relation.
There could be something, delay may not be always a factor here, but anyways, we are considering the
I can't marry
bail
also
application right
until I attain 21
He has already
years.
appeared. No,
there was no appeared, my lord.
Well, just, my lord. And in 161 as well as 164 also, my lord, she stated that in a statement that one thing is he is repeatedly, my lord, asking that as he is not converted to Islam, because of that he has not married him. And one thing I called so and so father, told him that since I did not convert to Islam, he raped me, and that he will not marry me, and he has done what he has done, and let me go. Malat. That is the statement 164. Malat. Thing is that Malat, there are tremendous pressure to convert herself. Malat. And one thing is that Malat, not 164, but in 161 Malat, he has given around 3 lakh rupees Malat to the boy.
She has given.
He has given. And she was Malat, doing work in one Malat, yes, at an animation center. Malat, she has given. And subsequently she stated that her father, his father returned around 1 lakh return. And 2 lakh not yet returned. That is good. And subsequently now this girl is Malat, tries to commit suicide. As per her statement, Malat. And ultimately, yes.
Anybody have said that, corroborated that that part of her statement, surrounding circumstances? Anything is there supporting her?
My lord, boy was born in Delhi. Subsequently, it was.
Where is the boy now?
Now it was given to a society and someone adopted, my lord.
Adoption home.
Adoption home.
See, the only thing that is weighing the mind of this court is that this FIR has been filed after
More than 2 years.
More than 2 years, and admittedly there were some relationship between the two. And she had then become pregnant, and then it appears also that the boy initially said will marry, and later he refused. Considering all this, now the question is, do you need the petitioner for custodial interrogation? He'll appear.
One common friend মানে just মানে সমান আগে প্ৰীতিক মোক ফোন কৰি তাৰ প্ৰেগনেন্সিৰ বিষয়ে কৈছিল পাৰভেজে ফোন কৰি তাক দায়িত্ব ল'বলৈ বুজাই দিছিল বাট ই নুশুনিলে মানে others also try to convince him মানে but he refused. That
is no one is denying. Mr. Chaudhary is not denying that part. In fact, that is why they have made those payments. The payments are being made for for taking care of the responsibility.
It's not legal, I have a moral responsibility.
Yes.
Page 18, my lord.
Though he is saying regarding the payment, but as per the statement of the girl, payment is return of the money. She has given 3 lakhs. 1 lakh is return. Yes.
You see, whatever.
As per the statement.
See, right now we are only considering about the liberty of the petitioner. Do we need to curtail or not? Correct? Yes.
Regarding the delay part, also kindly see para FIR.
Some lawyer has drafted it.
Para 3.
Yes.
Yes.
So kindly see, my lord, here, there was a promise to marry subsequently. Because the whole incident, my lord, that occurred, my lord,
But you see,
my lord.
right now, undoubtedly, the gravity of the offence is grave, but that alone cannot be a factor for denying. Correct? The other factors will also have to be taken into account.
Also, discretion, definitely, my lord, that part, no. But only thing, my lord, kindly see the subsequent part also, my lord. Not marrying, then disown her, my lord. Ultimately, why money was given, my lord? Because of the baby, my lord. He got pregnant, my lord, and they are not denying that it is not his, my lord. And my lord disowned her, my lord. And there was forceful, my lord, trying to convert her, forcing her. And there was no marriage, my lord. They persuaded her that we will be marrying you. So, my lord, that delay was there, my lord. And he went somewhere else. So, of anticipatory bill. And you see, I tried to abort also because it got late, my lord, couldn't do it. Thereafter, the baby, and she was, in fact, my lord, there are messages, my lord, I don't know whether it is in the diary or not, my lord, she was forced, my lord, to...
It's very unfortunate what has happened. That's a different thing.
Yes.
But you see...
164, she also stated that she was forced to drink alcohol and subsequently this.
That first incident, then, my lord, any relationship, my lord, initially it may be consensual, but it did not continue because once, my lord, somebody says no, my lord, that means no, my lord.
Right now, where does the petitioner stay? Are they staying nearby?
Petitioner, my lord.
No, he's
in Delhi, my lord. He's undergoing
And the victim?
Victim is in Guwahati.
So there can be no apprehension that the petitioner is going to threaten her or...
Instruction. He is nearby. about that.
He's in Delhi.
Delhi, my lord, I am undergoing that course, my lord, for seat.
My lord, and you see, my lord, unfortunately, but my lord, incident occurred, my lord. Specific allegation, my lord, that she was forced to drink, my lord, thereafter physical relationship. And
right.
thereafter she got pregnant. My lord, can you also go to the 164 and the...
My lord, I'll only request your lordship to have a look at page 18, my lord. Kindly look at my age. Until I attain the age of 21 years, I can't even marry. My date of birth is 4th of January 2004. Yes, my lord. What had happened is really unfortunate. There can be no manner of doubt. But then in the eyes of law, end of the tomorrow when there will be a trial, what will happen in this?
Then I shall pass the appropriate order after I go through the case.
Deeply, piece of
Is there any?
Is there received, my lord, earlier rejected by your lordship, my
Yes,
lord?
lordship.
Regarding
Where is
other
that order?
That order, lordship, will find on page 18, lordship.
Any change circumstances?
Yes, lordship, whatever, lordship. Initially, lordship, when the case was registered, it was under 366A, 433 and 34, lordship. That lordship, that time 6 of the POXO is not there, lordship. Now, lordship, subsequently 6 of the POXO Act was added, lordship. That is on, lordship, on 19.
So is added now.
Yes,
her date of birth is 22/8/2007. 16 years at the time of incident.
Now, lordship, as per allegation that is on reflected in the FIR, lordship, will find that, lordship, there was a marriage. Page 15, lordship. May I read the FIR, lordship?
Yes.
With reference to the subject cited above, I have the honor to state that and inform you that on 7/11/2023 at about 10 a.m., my minor daughter, namely such and such, aged at about 16 years, went to the Mankachor College to attend the classes as a student of higher secondary first year classes and has not returned home till today. Thus, sir, I, along with my family members, search in all places, including the houses of the different relatives, but failed to trace out her whereabout at any place. Thus, sir, subsequently, it could be learned from some reliable sources that the accused number 1, in connivance with other accused persons.
This we've already seen, yes, Mr. Borthakur?
Yes, lordship, the marriage proposed, there is a marriage, lordship. Had it been only, lordship, that...
But she is a minor.
But the only, lordship,
Otherwise,
15
finding
days
no
short.
materials against other accused persons, your lordship has granted.
Correct. This court has found from the statement of the victim girl that there are she has implicated the petitioner.
Yes,
On
sir.
that basis, bail was rejected.
But
so that fact has not changed.
Lordship, that day, lordship, that POXO is not there, lordship. When the
Does it make a difference?
Because, lordship, the medical examination is required because it is a case of, lordship, POXO is there, lordship. Whether she has been medically examined or not, that can be ascertained, lordship.
Hello, while post
now, lordship,
then, my lord, he is not.
I cannot hear both of you together. Let the APP make the submission now. Yes.
While my lord already POSCO added, my lord, victim is minor, then he is, my lord, not at all entitled for anticipatory bail from the materials available in the case.
Then, lordship, next. Lordship, can we come to the, lordship, the birth certificate? Lordship, only 15 days short of, that is on page 17, lordship. Page 17 is the birth certificate of the victim, lordship. Only 15 days shorter, lordship. She is 17 years, 11 months, 16 days, lordship. The marriage part is there, lordship. Had it not been that she has been kidnapped to having such sexual relation, lordship, there is a marriage part is also there. She is shorter of just 15 days, that's why, lordship, marriage could not be possible, lordship. That, lordship, criminal intention, lordship, is not there in that regard, lordship. There is a marriage proposal is there, lordship.
That will not change.
Now, lordship, this, as per instruction, lordship, this boy is ready to marry this girl, lordship. And she is now major, lordship.
All right. 46. 46. Heard Mr. B. Chaudhary?
Yes, Lord.
Learned counsel for the petitioner. Stop. Also heard Mr. P. Borthakur, learned APP state respondent. Stop. This is an application. This is a second application under Section 438 of the Code of Criminal Procedure 1973 for granting of anticipatory bail to the petitioner, i.e. MD Rajiul Islam, who has been apprehending arrest in connection with Bankachar Police Station case number 415 of 2023 within bracket corresponding to GR case number 1002 of 2023 registered under section 366 capital A 34334 of the IPC, read with section 6 of POCSO Act 2012.
That is added after 1 month of the first FIR.
Earlier by order dated 23/1/20, his father died on 26/2/1990. Prakash Chandra Burman, right? No.
Prabhat Chandra Burman. No, Prabhat Chandra Burman, that
What
is
is
different.
the name of the father of the informant?
This petitioner is relates to Prabhat Chandra Sharma.
Prabhat
Chandra Sharma, who died on 15/1/2000.
Chandra Sharma.
15/1/2000. 15 January.
Okay. And the power of attorney is dated?
Dated 19/6/2006.
All right.
But on verification, it appeared that this number of power of attorney in some others' name.
Okay. I'll have a look at it and I'll pass the appropriate order.
Publish.
Yes.
Is there for was call for in this?
Yes.
FIR is at page 80, Lord.
1 second, the file is not before this. Yes, page?
Page 80 is there.
80?
80. Allegation is on the basis of four LD law. One Pradeep Kumar Das has posed the LD and purchased the land and sold it to another person. So I am the bona fide purchaser of this case. I have submitted my bank statement. This mutation order, the moment the time of mutation has filed their objection also. And in they have also filed a title suit pending. I am having read party. They have also filed a complaint case.
You are saying you are the owner?
I am the owner.
Bona fide purchaser. This is what your case is. Yes?
Yes, Malat. Main culprit is one Pradeep Kumar Das Malat in case Malat. He made a sell deed Malat, manufactured sell deed Malat that as per the Malat record of the Malat registry Malat.
He had appeared?
Yes, he has
as per
appeared.
His interim?
Yes, he has appeared. Malat.
We'll make that absolute then.
Malat, yes. One main objection is that Malat Sarita Devi Jain for his son Malat made with the Malat persons and subsequently yes, he has given money. Subsequently applied for
He's the
mutation
purchaser.
also. Yes, purchaser. Considering the fact that it is strongly suspected that Fendi might have been influenced the government officials due to her strong financial position and thereby illegally gained the plot of land by virtue of mutation and purchase at a low rate. What is the market rate? Below that, she has purchased. That is the only might have. I will also state it like that. The might have. But that is the she is yes.
Heard Mr.
H. Agarwal.
H. Agarwal, learned counsel for the petitioner. Stop. Also heard Mr. K.K. Parasar, learned APP, Spot State respondent. Stop. The case diary call for has been placed. Stop. It may be mentioned that by order dated 5/1/2024, this court granted interim free arrest bail to the petitioner. Stop. Subject to conditions. Stop. Next para. Mr. K.K. Parashar, learned APP submits that the petitioner has appeared before the investigating officer in terms of the interim pre-arrest bail ordered dated 5/1/2024. So, he further submits that the petitioner's statement under Section 161 CRPC has been recorded. So, he further submits that it reveals from the information collected by the IO that it could be that the petitioner purchased the subject plot of land at a value which is less
than the
market value. Yeah.
Next, our bank statement.
Considering the fact that the petitioner is cooperating with the investigation, this court is of the considered view that further that custodial interrogation of the petitioner is not required for the ongoing investigation. Accordingly, the interim pre-arrest bail granted earlier by this court by order dated 5/1/2024 is hereby made absolute, subject of course to the following conditions. Number 1, cooperate with investigation. Number 2, inducement. Number 3, similar offence. This disposes of the anticipatory bail application.
I am obliged, Lord.
66 minutes charge sheet submitted.
Was on bail.
My lord, interim was not there.
Charge sheet submitted, you appear. This, yes, charge sheet white.
White CS number.
White CS number.
05/24.
05/24 dated
31/1/24.
31/1/24. Okay. Your name? H. A. Ahmed. H. A. Ahmed and other side KK Parasha. Disposed of. 67.
67 also charge sheet submitted.
On bail?
Not on it. Not
same order. Yes, charge sheet white.
Charge sheet number is 09/24.
09/24 dated
29/2/24.
29/2/24. The court, Mr. Parasa, in both the cases, in 66 before which court?
Here, this is my lord. 67 is before. Session court, my lord. Sunitpur.
In 67, Court of Session Judge Sunitpur. Tejpur. And in item 66, same court, Session Judge Sunitpur. Dispose of both. Yes. There is a supplement, in the supplementary list there is a part third matter. Anyone appearing there? Yes, we'll give you another date, there will be no time today. In item 68, due to paucity of time, further hearing could not be completed today. Stop. List this matter again on?
Next, 19, my lord. 19 or 20.
19 or 20. 19/3/2024.
All right. Also, in this case, the IA before your lordship is for suspension of sentence.
Take another date, there will not be much time now.
Definitely.
When do you want it?
I pray one thing, because lordship impugn judgment was passed in the year 2020.
We're giving a short date, when do you want it?
If your lordship hear the entire appeal, then may I pray for a hearing there if your lordship.
Is the appeal ready for hearing?
Yes, ready for you.
Ready for hearing, Mr. Parasha? In item 49, you say, let the connected criminal appeal be listed for hearing
on 26 or 28
on 26/3/2024, along with the instant I.
26 holiday.
28 lordship.
28. Yes. Next.
Obliged, lordship.
Why is it come for orders?
Lordship, actually, respondent number 2 has been served with the notice. They have duly appeared, but they have not filed the objection, Lordship. It should be listed for admission hearing, Lordship.
In item 50, you write list for admission hearing.
And LCR not yet received.
LCR is not, so then don't write that. It appears that the LCR has not been received. Stop. Reminder through the registry. List after 2 weeks. on a date to be fixed by the registry.
An I is there for suspension considered
on the next date.
Okay.
Yes. Next. Why is it for orders?
Interim order may be considered, Madam.
No, right now there is no time. Is the scanned copy of LCR have you received?
Not.
And respondent, have you taken steps?
I have taken steps. Madam, next date is on 13, Madam.
I think they have not. It's awaited. As per office note dated 6/3/2024, comma, service in respect of the respondent is awaited. Stop. List again on.
Madam, next date is Madam on.
This is not completed. List again after 1 week on a date to be fixed by the registry. Next.
The format. There is a format, Madam.
Yes, 52. Why is it for orders? None appears for the petitioner when the matter is called. List after 3 weeks on a date to be fixed by the registry. Why for orders, Mr. Nawaz?
Service is awaited on the respondent.
Await service report. Await service report. Stop. List after 2 weeks on a date to be fixed by the registry.
Interim order, madam. There's an interim order, madam.
Interim order, if any, shall continue till then.
People applies, madam.
Next.
Awaited service report.
Lordship,
54.
Lordship, I have appeared for the respondent. Today we have filed the wakalat number.
In item 54, you say that Mr.
B.H. Chaudhary.
Mr. B.H. Chaudhary submits that they have they are entering appearance in respect of respondent number 1 and have filed their wakalatnama today.
Yes.
Stop. Let the registry verify and place the same on record. Stop. List the matter after.
Lordship, can it be on this Friday, Lordship? There is a stay operating this Friday.
Let this matter be listed after 1 week on a date fixed by the registry. Interim, if any, shall continue. Next.
Highly obliged.
Please.
Yes. Why is it?
Service awaited, Lordship.
Service await service report.
Next date is 22.
List. We'll put it before that.
Before.
List again on
19/3/2024.
19/3/2024.
Highly obliged.
Yes. 56. There won't be time for hearing. We will give you another date. Due to paucity of time, hearing cannot be taken up today. Stop. List this matter again on 2/8/2024. List full. Okay, naam kita lo list.
করছে দেখো
এটা অফ করে না লাইফ অফ করে